Everyone, welcome to the Cleveland Metropolitan Bar Association. I am Ian Friedman. I'm an attorney here in Cleveland, and I will be moderating the four panels that we have here today. Our subject for which you're all here is Post-Dobbs, the legal and medical landscape of reproductive rights in Ohio. And I just want to go over kind of an introduction of some notes for a moment. The goal of this forum is to bring together members of the public, medical and legal professions to educate and discuss what reproductive health care looks like in Ohio after the United States Supreme Court case recently in Dobbs. We know many people have very strong viewpoints, beliefs, and emotions related to this subject. However, today's conversation is not a forum for political or personal venting. We will be taking questions both in person and online. However, the comments feature in Zoom has been disabled. In the audience, we will be accepting questions that are written on note cards and given to the CMBA's CEO, Becky Rupert McMahon. For those joining us on Zoom, you are encouraged to enter your questions into the Q&A function at the bottom of your screen. If you're on Facebook, feel free to use the chat function. So this program is awaiting approval from the Ohio Supreme Court for 4 hours of continuing legal education. In order to receive these optional credits, you must complete the live polls that will be administered throughout the program. The brief CLE survey that will be sent following this program must be completed as well. Credits will not be issued to those who view this program outside of Zoom, so Facebook Live attendees cannot be issued the CLE credits as was stated on the registration. I would like to, before we begin, and before I do my introductions here to my left, thank and acknowledge the Cleveland Metropolitan Bar Association for hosting this symposium, recognizing the need for education on this very important topic and getting it done so quickly. Specifically, as I said, our CEO, Becky Rupert McMahon, also Carrie Burns and Dominica Essie, and I'll explain to you why and what they've done over the last couple of weeks, but also those folks in my office who have been going around the clock to get this done, particularly Mara Hers and Mary Walsh, who have joined us here today. You have to understand that 2 weeks ago, the way that this all came to be was I received a call from a professional within the medical field on a Sunday, and the question was, what does tomorrow look like? And it was very clear during that call that there were going to be many questions from providers, professionals within the reproductive profession, and those questions were going to be posed to the legal profession. It was important, and it was clear at that moment that this symposium had to happen. The questions that we're going to be addressing here today are questions that are being addressed in rooms across the United States. And I'm very pleased to say that in just a matter of 2 weeks, this symposium came together with the help of those that I thanked. So what I would like to do is begin the program now. Excuse me. And I'm going to introduce our speakers. So on the far side to my left is Dr. Catherine Romanos. To her right is Maggie Scotese, and to Maggie's right and closest to me is Jordan Close. Now we are on tight time and we have a lot to talk about, so I could spend a lot of time talking about their bios, but if you just look at the materials that you've been provided, you'll see why we are so honored to have them here today speaking with us. So with that, we're going to go right into questions. And Dr. Romanos, this topic is obviously Abortion 101. What is an abortion? And the question that I have for you is, for those of us outside of the medical field, can you please explain exactly what an abortion entails, how it differs from contraception or miscarriages?
So thank you for having me, and I'm excited to be able to give you a little bit of Abortion 101. This is what I would give to medical students, essentially. And I think the first thing to understand is that the definition of abortion for physicians is very clear. And the second thing is that it's equally important to talk about what is not an abortion, because everyone is reading a lot lately and getting confused on what is an abortion, what's not an abortion. And so the first thing I want to make clear is that contraception, from a medical perspective, is not an abortion. There are many ways to prevent a pregnancy. You can prevent ovulation, you can delay ovulation, you can disable the sperm, you can make it unlikely that an embryo will implant into a uterus. But all of these things, from a medical perspective, are not an abortion. Similarly, I think a lot of people just get confused when you're talking about the difference between abortion and emergency contraception. Emergency contraception is not an abortion. Emergency contraception is preventing a pregnancy from forming or implanting. So that can be preventing ovulation, delaying ovulation, and then kind of a funny term we use is that we can create an inhospitable environment in the uterus for an embryo to implant, and in that way prevent a pregnancy. That is not an abortion. Even if there's an embryo, but if it is not implanted, then taking it out is not an abortion. The other thing to think about that is not an abortion is what is confusingly called a spontaneous abortion. Doctors use the word abortion to talk about a varied range of things that can happen to a uterus. And so you might say a spontaneous abortion or a miscarriage. And most people are starting to use the more general term early pregnancy loss. So an early pregnancy that never became a healthy growing pregnancy that is either lost naturally or there's some sort of medical intervention to help clear that pregnancy away. That was a pregnancy that was never going to grow. So even though we call it a spontaneous abortion, it's not an abortion. And then the last thing that you want to be really clear about is that an abortion is the termination of a pregnancy that has already implanted in the uterus. It is not the treatment of a pregnancy that has implanted outside the uterus. There are all kinds of really dangerous ways that a pregnancy can develop by developing outside of a healthy uterine wall. That's called an ectopic pregnancy. And there's crazy case stories about ectopic pregnancies in the liver and the cervix and the ovary and the fallopian tube, and the medical nerds get really into that. Treating those crazy conditions is not an abortion. One of my colleagues explained it really well by saying they are separate chapters in the textbook. Treating an ectopic pregnancy is not the same as treating an abortion.
Thank you, Dr. Romano. I've got actually a series of questions for you as we're talking about the medicine. So these next questions are for you as well. Can you please tell our audience what the different kinds of abortion procedures are?
So essentially, we have two different ways that we help people end a pregnancy. The first we call medication abortion, and the second can be called a procedural abortion, an in-clinic abortion. We try not to use the word surgery because it's kind of scary and it makes it sound bigger than it is, but some people might say a surgical abortion. For really early pregnancies, pregnancies that are less than 10 weeks, less than 12 weeks, it's quite common for people to use a medication regimen. And there are different regimens that can be used. They're all safe and effective. And it's really a patient's choice whether or not they might want to use a medication to terminate their pregnancy or have a more invasive procedure in the doctor's office. And the other term that I think people get confused about is D&C. A lot of people have heard of friends or older relatives having a D&C, a dilation and curettage. We don't really use that term anymore for the in-clinic procedure. We call it a dilation and suction. A little later in the pregnancy, you might call it a D&E or a dilation and evacuation. And then in special circumstances, you might do a kind of abortion that is called an induction, which is the same word that we use for inducing a pregnancy when you're going to have a live birth.
All right, thanks, doctor. So, doc, how does a person even know at what stage their pregnancy is? How can they determine what type of, or if, an abortion can be done?
So this is a really fun question to answer because most patients actually don't understand this. Most people who have had a baby don't understand it because, as I tell my patients, doctors make everything more confusing than it needs to be. So the way we're going to try and understand the question, how pregnant am I, is to say, what if today were the cutoff in Ohio right now for when you could or could not have an abortion? That would be about 6 weeks. It's really like 5 to 7, but let's say today is 6 weeks. If you are 6 weeks pregnant today, that would mean that 6 weeks ago you had a period. And then I tell patients, but we know you didn't get pregnant the day you started your period. You probably didn't even have sex that day. We know you got pregnant 2 weeks after that. Right? So your LMP, your last menstrual period, would have been June 13th. 2 weeks after that, when you were 2 weeks pregnant, you would have had sex. That would be July 11th. Today, you'd be 6 weeks from your period, 4 weeks from when you had sex. And then we would look forward to your estimated date of delivery, 40 weeks of pregnancy, as March 10th. Of next year. The reason this is really important to understand is the lawmakers didn't listen to this lecture before they made the law that said abortion is illegal after 20 weeks. They wrote the 20-week ban so that it says 20 weeks post-fertilization, which means 20 weeks from the 2 weeks, which means 22 weeks the way doctors talk about pregnancy. So I always say to patients, you know how we always talk about 9 months of pregnancy, but 40 weeks sounds like 10 months of pregnancy, and that's really demoralizing because you don't want to be pregnant for 10 months. That's why. We start counting from the first day of your last period, 2 weeks before you got pregnant. It's very confusing.
Yeah, so it's really important to emphasize that you are considered pregnant for 2 weeks before you have actually had sex that caused the conception of the pregnancy. So when we're talking about this 6-week ban or people being 6 weeks along, they're not actually 6 weeks from the time they conceived. It's closer to 4 weeks generally, if that. And so that is a very short timeline for you to have any idea that you are pregnant, assuming you will have regular menstrual cycles.
Thanks, Maggie. So last question for you, Dr. Romanos, not for the whole session, but until I move to Maggie and Jordan. And the question is, knowing that there are different types of medical abortions, can you walk us through the different types and processes, please?
So most medical abortions right now consist of the use of 2 different medicines, mifepristone and misoprostol. The mifepristone, I tell patients, blocks the hormone progesterone that keeps the pregnancy growing. If you took it today, you'd feel fine. You wouldn't really notice anything happening. And then sometime later tonight or tomorrow or even Wednesday, you would take a second set of medicine called misoprostol. For those of you who have ever been in a labor and delivery room, it's also called Cytotec, and it makes your uterus cramp and expel the pregnancy. And as it makes your uterus cramp, you have everything else in your body cramp too. So you get nausea and diarrhea and low-grade fever. And it's a couple hours of being kind of miserable at home, and then it backs off. And a lot of times when we get phone calls from people during that process, it's not because anything is going horribly wrong. It's just a little scary to do at home. But it is safe and effective, and about 1% of people end up needing some sort of emergency care afterwards. And this is from a website for the mifepristone medication. It's from their patient handout, so that's helpful. Oh, I should talk about, there are other ways to do this, right? So mifepristone and misoprostol is the most effective, most prevalent way of doing a medication abortion. There's also a way to do it with just misoprostol or just Cytotec. It's a little easier for people to have Cytotec or for regular doctors to prescribe Cytotec. It's just as safe, just as effective. And then there's an older regimen that uses methotrexate and misoprostol. And the reason it's important to know about that regimen is that is the same regimen that is used if there's an ectopic pregnancy. Sometimes you can treat an ectopic pregnancy with methotrexate as well.
Thanks, doctor. So I'm going to turn to Maggie and Jordan and ask you, other than medical abortions, which people can administer in part on their own, there are also truly self-managed abortions. And so if you can let our audience know, what does that entail?
Yeah, so self-managed abortion it means different things to different people. So I'm going to talk about what some people might mean when they talk about self-managed abortion. As Ian and Catherine have both referenced, that oftentimes when people get a medication abortion, they will take the first pill or the first dosage of mifepristone in clinic, and then will take the misoprostol when they return home, either later that day, in a couple of days, etc. But you can do an abortion simply with misoprostol on your own. And so that is one way that you can actually self-manage your abortion. The World Health Organization has guidelines and has a regimen for ending pregnancies past 10 weeks and before 10 weeks using misoprostol alone. And that method of ending the pregnancy is not detectable through a blood test. And so if somebody were to attempt a self-managed abortion and it was unsuccessful, or they had large bleeding afterwards, they could still go to an emergency medical facility and seek medical treatment, and they would not be able to tell through a blood test whether you had a spontaneous abortion or an early pregnancy loss versus having used misoprostol to induce the abortion itself. There are also herbs that you can use to manage abortion and to induce abortion. In fact, one of the herbs that was traditionally used in Appalachia, the red clover, is what we have in our logo currently. And so there is information online about herbal remedies. And then instrumentation is also an option. Catherine talked about the procedural abortion that you can get in clinic. There are similar instruments that you can buy that are not do not use electricity but use the same suction techniques that can be used for period management, menstrual management, to get the actual menstrual blood out of the uterus, whether or not the person is pregnant. That same device can also be used for ending an abortion or ending a pregnancy. Accompaniment is another form of self-managed abortion. This is very prevalent in Latin America countries where abortion was not legalized for many years. And so they are trained advocates who have studied the WHO guidelines to be able to help support somebody through a self-managed abortion and may help them procure the medication to do so, and will sit with them and support them through that process. You can also use an abortion doula for a similar experience if you are self-managing abortion or having an in-clinic abortion and just want someone to support you as you take the rest of your medication when you get home. There are also options such as telemedicine, where you can call a doctor that's either located in a state where abortion is legal for you to access or where a country where it is legal for you to access, and they will prescribe the medication and potentially send it to your house. You can learn more about that at Plan C Pills, as well as a couple of other websites that we can have information about later if you're interested. And then also people self-source their medication. So many of the medicines that are used for abortion, misoprostol originally was developed for ulcer treatment, and it was discovered that it was an abortifacient after women were miscarrying after taking it for ulcers during pregnancy. Methotrexate, again, is also another drug that is used for something other than miscarriage management or abortions. It's used for the treatment of rheumatoid arthritis. So you may have seen and heard in the news about people who use methotrexate for their rheumatoid arthritis and their cancer treatments no longer being able to access that drug anymore under the new bans. And so it's really important when we're talking about these medicines that people do self-source them, and you know that they're used to treat things other than unwanted pregnancies, because anything that obstructs the access to these medicines will obstruct the access for folks with disabilities who need to access them for reasons that may have nothing to do with ending an unwanted pregnancy.
Perfect. Thanks, Maggie. Jordan, please.
Yes, that is a super important note because as we're seeing more of these bans, more of these barriers to people accessing care, a lot of the talking points in the mainstream repro sphere have been educating people about self-managed abortion, about pills that you can order online through Plan C pills, aid access. There's so many different options, but we need to be really clear that those options are not available for everyone. While people very much should have the right to manage their own abortions in the safety of their home, that is just simply not a choice for everyone. I had an in-clinic abortion, and that was my number one choice. I was not interested in having an abortion at home, and we need to make sure that we are highlighting that. A lot of people do not feel safe having abortions at home, and we don't want to ever stigmatize one method of abortion over another. There's also heavy stigmatization of herbal abortions. And the women that created this movement for us, especially in Ohio, especially in Appalachia, have led the way for us to be in rooms like this, having conversations like this. And we need to honor and recognize where we came from and not leave them behind. Herbal abortions, in-clinic abortions, self-managed abortions, whether it's in clinic or at home, are all valid. And so when we continue conversations about what the legal risk is for any kind of abortion, I just want to highlight that there are many different ways that a person can be criminalized based on how they choose to end their pregnancy. And that is, for lack of a better term, fucked up. So I tried really hard to think of a different word. So yes, just make sure that we're not stigmatizing any kind of abortion, whether it is a old method from Appalachia or whether it is prescribed by a doctor.
Thank you, Jordan. So Maggie, I'd like to address this question with you. In addition to the physical cost to a person who terminates one's pregnancy, what are the tangible costs of the procedures? Specifically, is a self-managed or medical abortion more financially accessible than a procedural abortion?
Yeah, this is something that I didn't have any concept of before I got involved in this work, how truly expensive abortion care is for anybody attempting to access it. So generally speaking, abortion is not covered under most health insurances. So most people are going to have to pay out of pocket for the entirety of the cost of their procedure. Generally speaking, in the state of Ohio, the earliest you can get a procedure is going to be the lowest cost you can get before 10 weeks. And that's going to be around $550 just for that procedure. That doesn't include the mandatory 24-hour before consultation appointment, which can cost another $200 easily. And that is assuming that you can get in under that deadline. So once you get past 10 weeks, then the cost of the procedure goes up about every 2 weeks. So when you hear about folks who are struggling to pay for their procedure and they wait a little while to raise the money and then they still can't afford the procedure, that's why. Because every 2 weeks, the cost of that procedure is getting more and more expensive and quite quickly can get into the thousands of dollars. And that's assuming that there are no complications or they don't need any specific medical interventions other than the abortion. And then that doesn't even cover the cost of accessing that care outside of the clinic. So if you have to go to the clinic twice, that means that's 2 round trips to your clinic, which could be easily in Ohio an hour away. That means you may have to stay overnight at a hotel. That means you might have to get another babysitter for your kids. That means you're going to have to pay for dinner somewhere that's not your house, generally speaking. And all of these barriers are going up now that most folks in Ohio are having to leave the state to access care. So we know from research that was done earlier this year that folks in Ohio are having to travel around 300 miles each way to access care at this point because it's not available in state. And that is incredibly expensive, especially with the gas prices these days. And again, that doesn't even touch the procedure costs. And so, yes, doing something that is self-managed would be more financially accessible for many folks. I believe through aid access, if you order pills, it's about $100 for the regimen. But that's still a pretty big barrier for a lot of the folks that we serve. About 75% of folks who seek abortion care are at or below or 190% of the federal poverty line, which is not very much money. And so you are very tight at that point. $100 is certainly easier to swallow than $500 to get that same medication in clinic. But it still is going to be hard to access for a lot of folks. And that means that you're self-managing at home, which for some people is exactly what they want. Some people that's harder because their home is not a safe place for them. And so they don't want to be at risk of their partner, or their parent, somebody like that discovering what they're doing.
Thank you, Maggie. Dr. Romanos, I'd like to return to you for a moment and ask you to kind of share with us what we need to know about epidemiology of abortions.
So the most important thing to understand about this epidemiology is that it is so much more common than anyone wants to admit, right? And I always say that to patients because everyone who gets to the clinic feels alone. They feel like they're the only one they know who's ever had to do this. When in actuality, we have data that says 1 in 4 women will have an abortion during their reproductive years. We know that quote is a little bit out of date because people who identify as other than woman also have abortions, and those are probably undercounted. But we know that 1 in 4 women have an abortion. The most recent good data that we have was that 18% of pregnancies in 2017 ended in abortion. And that was coming down since 2014. And that's pretty much continued. We've had fewer and fewer abortions in this country over the last decade or so. So in 2017, that number was somewhere around 800,000, and that was down from 900 and something thousand. And as Maggie was saying, 3/4 of the people are considered poor or low income. 62% identify as religious. 59% already have at least 1 child. And 60%, the bulk, are in their 20s, with only a minority being under 20 and only 4% considered minors. That's kind of the medical data we have. There's also this whole literature about people who are having abortions that we can't necessarily count. And I'll have Maggie comment on that.
Yeah, so as we spoke earlier, not everybody seeks in-clinic care for a variety of reasons. That might be because they are an identity that is not taken care of well by the medical profession. Black women specifically are at higher risk of medical malpractice and not receiving the care necessary to protect them. So they may choose to self-manage. Folks in rural communities are less likely to be able to access in-clinic care. So we know in Appalachia, our counts of abortion seekers are probably undercounting because it's so hard for Appalachians to actually access in-clinic abortion care. And as Catherine spoke to, we know that about 60% of abortion seekers are parents, which means we know that these folks know the decision that they're making, and we know that they already have a child at home. And for many of them, the choice might be to choose to care for the children they already have at home and not bring another child into a picture where they cannot sustain it.
Thanks, Maggie. Jordan, I'm going to ask you a question, if you would. I know Becky's got several questions from the audience, but I've got 2 more questions here. First for you, and then Maggie, I'll ask you to make last comment. Jordan, with the work that each of you do, are there any stories that you would want to highlight? Because you work with a lot of patients. And so if you could kind of educate us a little bit from the patient perspective as to where we are today.
Yes, so I will speak mainly about my own experience having an abortion. I don't speculate on why other people have abortions. That is their business. I had an abortion in 2015 in Ohio. I was living in Logan County at the time, which, if you're familiar with Bell Fountain, it is a place. And like the rest of Ohio, did not have comprehensive sex education. I was 18 years old and in a long-term relationship with my high school sweetheart. And we were together for a little over 2 years, and I found out I was pregnant. And the only reason I found out I was pregnant at the time was because my dog started acting up. It wasn't because I felt any different. I did not have a regular period, so I was not tracking that. So if Noah, the German Shepherd, had not alerted me, we would probably be in a very different place. But that happened, and I took a test. It was positive. I knew immediately that choosing to end my pregnancy, having an abortion, was the choice that I wanted to make. At that time, there were no abortion clinics in Logan County. The closest clinic to me was in Columbus, Founders, which is unfortunately no longer operating. And I had to book my consultation, I think a couple weeks out from that, to be able to afford it. I did not know about the existence of abortion funds at that time. I believe my consultation cost in 2015 was like $250, which was a lot for me at 18 years old. I went to my consultation, and everyone was lovely. I had never experienced being in an abortion clinic. I had never been to a Planned Parenthood. I had only gone to my primary care physician. And everything I had heard from the media was that abortion was this like sad, detrimental experience that no one wanted to have, and it was a hard decision, and none of that was true for me. It's not true for the majority of people that have abortions. I knew immediately that I wanted to have an abortion. My experience was amazing. From the secretary at the front desk to the nurse that drew my blood and did my ultrasound to my doctor. I was talking to him about my favorite restaurants during my in-clinic abortion. Side tip, if you have never been to the diner at the Urbana airport, it is very good. And after I had my abortion, it was like a 5-minute procedure, very quick. I was in the observation room with another Black woman that had been with me through all of the waiting rooms prior to our procedures. And she was incredibly calming. She told me that I was going to be okay. They gave me snacks. You wouldn't think that Cheez-Its and apple juice go together, but on that day they did, and it was delish. And then I went home, and I watched Game of Thrones with my dog and had a slushie and chicken tenders. And that is a very common abortion story. It was just another Tuesday for me, and I didn't share my abortion story for over a year after I had my abortion, not because I was ashamed of my decision, but because I thought that there was something wrong with me because I was not upset about my abortion. I never second-guessed it. I don't have any regrets. The immediate feeling I had afterwards was relief, which is, again, what the majority of people that have abortions feel after their experience. And the first time I shared my story publicly was one of the first times that a, quote, heartbeat bill was introduced in the Ohio legislature. And I shared it on Facebook for the first time. And so many people reached out to me and said that either they had also had an abortion and hadn't felt comfortable speaking out about it, and that they wanted to know how they could get involved. And so that led me to volunteering with Abortion Fund of Ohio and Pro-Choice Ohio, and then I got involved with We Testify, a national abortion storytelling organization. And I have been really honored to hear so many different kinds of abortion stories. I always say that abortion stories are like snowflakes, no one is the same, but on the whole, people do not regret their abortions. The barriers that I experienced were not moral, they were societal, they were financial, they were logistical because of the bans in place in Ohio. And a lot of people have experienced the same. And so when we're talking about abortion in any of its variations, making sure that we are doing our best to destigmatize and normalize this very common, very safe medical procedure is really important to the heart of the work that we're doing. Because if we can't say the word abortion, if we're not centering people that have had abortions, if you're having any conversations about decisions about bodily autonomy without someone in the room that has had an abortion, you are not doing the work correctly.
Thank you. Thank you very much. Maggie, last question for you before Becky asks some questions. How can those of us outside of the medical profession assist patients in need of an abortion?
Yeah, so as Jordan spoke to just now, for many abortion seekers, the biggest harm that they experience when seeking their abortion is not from the abortion itself, it is from the barriers to accessing that abortion. So there are lots of ways that folks who are not medical providers can get involved and help support folks who want to access care. One of the best ways to get involved is to find out who your local abortion fund is and get connected with them. You might be asking, what is an abortion fund and what do you do? So all of those barriers we've discussed, the cost of a hotel, the cost of transportation, the cost of childcare, talking to somebody about your abortion, deciding what abortion procedure is right for you, those are all things that an abortion fund can potentially help somebody with. And so we are Ohio's statewide abortion fund. Patients can call us directly and tell us whether or not they are concerned about not being able to access abortion care for a financial or practical logistical reason, and our case managers will help them try and resolve that issue, whether it's getting them a hotel booked, making sure they have money to afford childcare, whatever their barrier is. If they just don't understand the clinic website, we'll sit there with them and walk through how to figure out what forms they need to sign so that when they get to their appointment, they're not at risk of missing their appointment or being rescheduled. We also have amazing volunteer programs where we just deliver emergency contraception to community partners so that folks can access EC, which if you go to Kroger and try and buy it, it's like $50 to $70, which is really expensive. And we can give it out for free. We try and educate folks on how to talk about abortion because that's one of the most powerful things you can do is talking about abortion in an honest and unstigmatizing way, making sure that you know that not everybody who seeks an abortion is a woman. There are people of all genders who need access to abortion care. And even though Dr. Romano spoke about what is and is not an abortion, it's also really important to understand, as she referenced, that lawmakers often don't have any of this context. So just because the ban is on abortion does not mean it's not having impacts outside of abortion seekers that are causing these waves of harm across our communities.
Very good. Thank you very, very much for the 101 here this afternoon. Becky, if you would, please, any questions from the audience?
Yeah, we've got quite a few. And let me remind the folks here in the audience, if you have questions, members of my staff are walking around with note cards. We are taking questions if you write them in advance. And also on Zoom and on Facebook, feel free to use the Q&A or the chat feature to submit your questions. So Dr. Romanos, let me come to you with a couple of questions. A couple of them are quick. Regarding timing of pregnancy, you shared your slides about when the weeks get started counting. So the question is this: does that mean that every potentially ovulating person is walking around at least some number of days pregnant? If their first day of menstruation was yesterday, are they 1 day pregnant today?
Yes. You could see how that's confusing.
Right. Next question. So many legal definitions of abortion refer to terminating the life of unborn humans. Quote unquote, unborn human is often defined to mean a member of the species Homo sapiens from fertilization to live birth. Again, doctor, for you, not from a legal perspective, but from a medical perspective, doesn't contraception preventing implantation of a fertilized egg qualify as an abortion?
From a medical perspective, no. From a personal perspective, maybe, right? I have patients who strongly believe that a fertilized egg is of value and of huge value to them, of such value that they won't use an intrauterine device for contraception. That is their choice. That's where they've put their value, right, in that fertilized egg. But from a medical perspective, the medical definition of abortion is the interruption of a pregnancy that has already implanted.
Next question, also for you, doctor. Is an induction abortion the same as a dilation and extraction or partial birth abortion?
It is not the same as a dilation and extraction, and it is not the same as a partial birth abortion. An induction abortion might happen if a patient has a sad situation where there's a fetal anomaly that maybe the baby wouldn't survive in the womb until delivery. And so a family might decide that they want to induce delivery rather than wait for the demise to occur naturally. And in choosing an induction abortion, they would have the option to deliver and then spend some time with that child. And that's a really personal decision. And you can imagine that in those decisions, there's no good answer, right? You're choosing between a couple really bad options, and you just want to have all those options available to people for people to choose from.
I have two more questions, and let me just say to both of those, if you don't feel qualified to answer the question, feel free to pass. We do have some other panels coming up that might be more appropriate.
Okay, I hope
For
I
you,
didn't say
doctor.
something wrong.
Nope, I got it. Next question is this. What happens if the Ohio legislature bans the prescription of abortion medications?
I mean, they're allowed to do that.
I think the question is it relates to then your ability as a physician to treat patients who are in need of abortion.
So if the Ohio legislature bans medication abortion, I will not provide medical abortion, right? Doctors are rule followers. We only want to follow the law. We don't want to break the law. If they ban medication abortion, we will not provide it. If that happens, it means I will be forced to practice medicine that goes against my conscience. And they have already passed some laws that talk about the conscience of physicians in the provision of care. And even since Dobbs came down, I am violating my conscience by following the law.
Okay, my last question then that we have, again, if this is outside of your area of expertise, doctor, not meaning to put the spotlight all on you, from your perspective, does telehealth from an out-of-state doctor create risk of practicing medicine without a license?
Oh, you have to ask the lawyers that
That's what I
question.
figured you were going to answer.
And I really hope they have a clear answer because I am excited to hear it.
Clear, maybe not. There are some other questions. I will say there are other questions, but they're not really right for this panel, so we're going to save them until later. So don't be upset if you haven't gotten your question asked yet.
So thank you, Becky. And Dr. Romanos, you've been on the hot seat here, and a question actually came to me. If you can share with us kind of what a day in the life of your practice is, pre-Dobbs, now post-Dobbs. How has that changed?
It's really different. So I work at an abortion clinic in Dayton, and I would say pre-Dobbs, I was seeing anywhere between 40 and 60 patients a day. Half those were for the first visit, the consent visit, and half of those were to start the abortion process. And down from 40 to 60 a day, I'm seeing maybe 6 to 10 patients a day. And in there are a number of patients that I'm not seeing because I can't take care of them. So I might meet them and help explain why we can't take care of them. But we're seeing far fewer patients. I've never been in a routine outpatient clinical setting where patients and staff are crying together all the time, right? That happens in emergency rooms. It happens when horrible things happen in the operating room. But to be in an outpatient setting where patients and staff are crying every day has been really traumatic for everybody.
Maggie?
I was going to say, I'd like to answer that from the fun perspective, because I think most of the patients that you're no longer seeing are coming to us. And similarly, it is the emotional toll that this is taking on our patients and our staff cannot be overstated. On decision day alone, we got 71 calls from patients who found out that they had their appointments canceled and now had to reschedule their appointments out of state. And many of them, it wasn't going to be the next day. We know that many of our clinic partners are now booking 3-4 weeks out. So that's now 2 price raises from the time they contacted us. And that's a whole month of being pregnant when you do not want to be. We know that patients are scrambling. There are folks who are seeking abortions who aren't even really sure that they want one at this point, but they're terrified of losing the option to make that decision. And the price and the impact it's having on them is terrifying, because even if they get to us, even if they find out that they're pregnant at 4 weeks, getting into a clinic and making sure that they can get their procedure before they are too far along, we know from our clinic partners that patients will come in for their first visit on a Friday and they'll be good to go, or they'll come in on a Saturday and they'll be good to go, and they'll schedule their appointment for Monday, and they come in on Monday and they no longer can get that procedure.
Thank you. And I see Becky walking up with another question, so we'll finish it with this question, Becky.
Oh, that's a lot of pressure because we got 8 all at once.
Oh, 8. All
Yeah,
right.
but we won't go
One
8.
question, 8 parts. Go ahead.
We won't go 8. Okay. And let me just ask this to Maggie and Jordan. So can you talk a little bit about the socioeconomic effects of people who cannot access abortion care?
We know that it drives them further into poverty. We know that they're at higher risk of domestic violence. We know they're at higher risk of losing their jobs. Oftentimes, an unintended pregnancy and inability to access abortion control can be a turning point in somebody's life that can really devastate their future. Because many of the folks who reach out to us, many of the folks that seek abortion, cannot afford to continue that pregnancy, and the state doesn't help them. They're stuck for many cases.
Yes, and I also just like to name that Ohio already has one of the worst rates of Black infant and maternal mortality. And so saying to someone, especially Black and brown people, especially Black and brown women, that they have to move forward with a pregnancy that they know is not right for them, only has a ripple effect on every aspect of their life. It impacts their families and their communities widely. It does not just affect one individual.
Dr. Romano, what impact, from a medical perspective, what impact will abortion bans have on IVF?
So from a medical perspective, that's easy. It's not an abortion if the embryo hasn't implanted into a uterus. The question is, will the legislature try to change the medical textbook, right? But for me, that's not an abortion if you just have an embryo that's not implanted.
Okay, and I've got 2 last questions for the doctor. I know I'm pushing up against our time limit here. What is an incomplete abortion?
An incomplete abortion can happen either after an elective abortion, after a medication abortion, or after an in-clinic procedure, or after the start of a miscarriage or the start of an early pregnancy loss. So if someone comes in and they are symptomatic, they have cramping or bleeding or they're uncomfortable, and an ultrasound tells us there's still something in their uterus, we would call that an incomplete abortion. A lot of times it's just blood clots, but it's called an incomplete abortion. And if a doctor saw a patient for an incomplete abortion in Ohio today, there would be no reason they wouldn't be able to take care of them.
Right. Last question for me. Can you describe the process for performing an emergency abortion at your clinic in light of the requirements of the new Ohio law and what Attorney General Dave Yost referred to for the 10-year-old rape victim?
Those emergency requirements have always applied more to hospital-based abortions. The clinics do more routine care, and high-level care like that has always happened in the hospital.
Very good. So I would like to thank all 3 of you for being here. If everyone please give our panelists a hand. So as those of you in the audience and those who are watching on the computer can see, where we're starting here with the 101 is kind of taking us through the spectrum today of really what abortion is and what a lot of us just frankly did not know. So thank you for coming here today and sharing your experiences and your professionalism and stories. We appreciate you. Thank you, Jordan. Appreciate it. Thanks, Maggie. Thanks, Doc. Okay, so next, what we're going to do is we're switching to a Law 101 panel. And this seminar was really designed, come on up, please. This seminar was really designed for those in the medical and kind of social aspect of this, as panel one was, to kind of talk to the lawyers a little bit and the public. And now those questions that were being asked of the lawyers are now going to be addressed by counsel who are here coming to the table. And I will grab number 2.
I'm good. How are you?
Good, good. Thank you. All right, so to this same also as our last speakers, the bios of our panelists that are up on the stage now are in your materials. So take a look at it and you'll see exactly why they're here, their experiences and their expertise within kind of the realm of law and criminal law in particular, because a lot of the questions have been coming up as to, can I do this? Can I do that? What happens if I do this? And that's why this panel is here. So to my far left at the end of the table is Jen Driscoll from the Cuyahoga County Prosecutor's Office, where she's the supervisor of the Major Trial Unit. In the middle is Madeline Grant, a criminal defense attorney who I'm honored to work with at our firm. And then closest to me is Diane Monash, who is a partner and director of litigation, training, and pro bono activities at Ice Miller Legal Counsel. I'd like to thank the three of you for being here today. And Diane, I know that you all are just going to kind of talk, but I'm going to start with you and just put a question to you real quick. You could just kind of talk about maybe overview kind of topics that you feel are important, and kind of, I guess it's a question open for all three of you, but you were closest to me, so I...
Sure, no problem. Thank you for having me, by the way. I think we're just going to generally talk about the law today. From a really 30,000-foot perspective. I think none of the topics that we're going to talk about will really get in the weeds. At this point, I think it's good to kind of stay at a higher level. We'll talk about the law, sort of best practices, what to look for. I know when we talk about the law in particular, Jen is going to talk about what definitions exist in our law currently. We're going to talk about things like complicity, aiding and abetting. And again, I think generally our conversations will be from a 30,000-foot perspective. But what we really want to do is give an overview of a number of things for you all to be thinking about, to be cognizant about. Not here certainly to create any kind of paranoia, but rather really here to give you information and knowledge, which will hopefully really set you up for success.
Thank you. So with the heart, I'm just going to jump to it. In our last panel, there was reference to the heartbeat bill, and that's obviously a subject that so many in Ohio have been discussing. And so my question is, with the heartbeat bill now in place, what is the state of law in Ohio, and how does the Ohio Revised Code, and for those of you who are watching, the Ohio Revised Code are kind of the code that we operate and the laws that we operate within. How does the Ohio Revised Code categorize the Ohio heartbeat bill?
I'll jump in here, Ian. So although the heartbeat bill is new, there have been definitions within the ORC, or the Ohio Revised Code, pertaining to abortion and what abortion has been defined as. And that is the purposeful termination of a human pregnancy by any person, including the pregnant woman herself, with an intention other than to produce a live birth or to remove a dead fetus or embryo. With the implementation of the heartbeat bill, what we have to really be cognizant of is the person who intends to perform or induce an abortion on a pregnant woman shall determine whether there is a detectable fetal heartbeat of the unborn human individual the pregnant woman is carrying. Here's what's important. The method of determining the presence of a fetal heartbeat shall be consistent with the person's good faith understanding of standard medical practice. What is that? I would submit, I think it's pretty ambiguous. In terms of that, there are different methods. What is that good faith understanding?
Yeah, I would agree. And I think, we've talked about this extensively in preparation for this panel. I think there is so much ambiguity there as to what the good faith understanding is. And I think also it's important to understand and appreciate from, from my conversations with providers in preparation for this, that standard could change. And that's something that everybody needs to not only be aware of, both, whether it's patients, volunteers, providers, and everyone in between, but what is their good faith understanding, and whether or not that good faith understanding is in compliance with the laws in place at the time and what they're to be carrying out in order to execute that abortion.
And I think we saw that early in the first panel, where the doctor's talking about her conscience and what her conscience is, and the laws as they're made with the 6 weeks, although the first 2 weeks are when you're in your menstrual cycle. So who is making this determination of a good faith understanding of standard medical practice? Is it the doctors? Is it the lawmakers? Who is it? And I think that furthers the ambiguity.
Okay, thank you. Question is, with different states having different laws, where does their jurisdiction come into play? So people have been asking, what about jurisdiction, Ohio to other states? Does that change things if one's leaving Ohio and so forth? So if you could please talk to our audience about jurisdiction.
Yeah, so I think in the last few weeks, one of the most common questions has been jurisdiction, and how, like Ian said, how does that play into what providers can do, what patients can do, anyone that's trying to assist someone potentially in procuring an abortion out of state, how far can they go in that assistance? So we know that in the state of Ohio, there's a number of ways that jurisdiction can be implicated. And I think, if we want to break this down, some of the more important things to, at least, as Diane mentioned, we're really here to give some things to think about. We're highlighting, at least as you navigate this process, where your thoughts should be going. So if you look at number 2, this is kind of where we consider probably the meat of the statute's going to be as it relates to abortion. So this would implicate anybody that's in the state of Ohio that either attempts to commit, is guilty of complicity, and or conspires to commit an offense in another jurisdiction. That offense, this is the most important part, needs to be an offense both in the state of Ohio and in the jurisdiction in which that person is quote unquote committing the offense or attempting to commit that offense. So I think, now, again, as Diane mentioned, we are not here to scare anybody, but I'm hoping that this section will potentially give everybody a slight deep breath, in the sense that it's important that the offense be an offense in both jurisdictions. So we cannot give any advice or give any affirmatives as to whether or not assisting somebody, let's say, for example, to go to a state in which it is legal to procure that abortion, whether or not that assistance or that direction, so to speak, would be, Ohio would likely not have jurisdiction over that. However, how different prosecutors, and Jen's going to get into this as far as the prosecutorial discretion and what the map looks like, what a certain prosecutor in a certain county in Ohio is going to do, or how they're going to choose to interpret this, is unknown at this point. And the unknown is very scary, I think, both for us as lawyers and for counseling clients. So one thing to note and to really be aware of is that one of the subsections of the jurisdiction statute specifically says that the section shall be liberally construed, consistent with constitutional limitations, to allow the state the broadest possible discretion, jurisdiction over offenses and persons committing offenses in or affecting the state. That in and of itself, as an attorney, I would say, makes me very, weary of how they can stretch this jurisdictional statute and where they can, where jurisdiction can be implicated as people are navigating this process. So again, I want to be very clear, we are not intending to scare anybody, but I think these are things that everyone should be thinking about as they are, pursuing or navigating this process.
I think another important portion of that, when we were talking about the telemedicine, and under subsection 4, it's not up here at this point, but while out of this state, the person omits to perform a legal duty imposed by the laws of this state. That would mean that if you're in Michigan where it's okay, and you're going to telemedicine and you're going to send that prescription into an Ohio patient, that's not comporting with the laws of the state of Ohio. And could there be implications there? Again, things to think about.
Yeah, and I think panel 3 is going to get into a little bit more about what's to come, but we understand that there is, House Bill 704 is attempting to create, I guess in layman's terms, it's attempting to give a fetus and an unborn child the same rights and protections. So in doing so, I think as Jen pointed out in number 4, if a physician, let's say out of state, were to assist a patient in the state of Ohio with procuring the medication to either self-administer or to get a medication abortion, and that was affecting the legitimate interest of a person in the state of Ohio, which under that new bill could potentially implicate the fetus, I think that's something else as we move forward here to keep in mind.
I think also when we're thinking about, well, it might give you some comfort, if you will, that it needs to be within Ohio.
You've got the sensitive
Oh,
mic.
sorry.
So.
I would also just say to be cognizant of, let's say a driver, for instance, right? Starting from one location and going to a different county. I know I'm from Franklin County, Ohio, and Zach Klein, our city prosecutor, has indicated that he will not be pursuing any charges with respect to abortions. And so I say that because Delaware County, a companion county, or Licking County, obviously their city attorneys, it's much more rural counties, and they have not made the same statements or proclamations or policy decisions. So I will say that there can be companion jurisdiction. You start in one county and you end up in another, but you're still within Ohio. Just to be cognizant of sort of that footprint as well when you're thinking about jurisdictional issues, but still within the state of Ohio.
So that's a great segue, and thank you, because what we're hearing is of our 88 counties, things are going to be done a little bit differently, and we don't know yet how it's going to unfold. But the word discretion came up, and particularly prosecutorial discretion. If you can let us know what that is, please, and how does that play into the last question, which is the jurisdictional element?
So a prosecutor has the discretion whether or not to pursue charges, and that could be based on a number of different things. If I don't believe we can sustain a conviction, I cannot move forward ethically in seeking a prosecution. My boss, Mike O'Malley, has indicated that he is not going to go after abortions at this time in Cuyahoga County. And it would be a felony of the 5th degree, so it would be the county. So I understand that Zach Klein in Columbus, who's the city prosecutor, has said that, but he's also recognized that it's
And Gary has not said that. Gary Tyack.
correct, right.
Gary has been silent.
And so he prosecutes misdemeanors, and this would be a felony. So I think Mike O'Malley is the only prosecutor in the 88 counties who's declined to move forward with prosecutions of abortions. I know the Cleveland mayor, Justin Bibb, has come forward and also stated that he does not intend to seek out prosecutions for such a thing. But again, that is a municipal level as opposed to. So when we're looking at this map, 1 out of 88 has declined to move forward or stated up front that he's not going to move forward with prosecutions. So that leaves 87 other counties. And when we're talking the jurisdiction, we don't know what they're going to do in those 87 other counties. If they're thinking in their head, no, we're not going to pursue it, or if they're thinking, I'm going to, because it must be known, as the Ohio Prosecuting Attorneys Association has stated, prosecutors are not policymakers. They take an oath to uphold the Constitution of the United States and the Constitution and the laws of the state of Ohio. They do not get to decide which laws to enforce and which ones not to. That was the stance from the OPAA. Now, taking a step back, we need evidence to prosecute. We need, again, as I stated in the beginning, if I don't believe I could sustain a conviction, we cannot move forward. And so then it gets into a lot of other questions of how could we sustain a conviction? How could we gather the evidence in all of this, and why? The basic why. Go back to the map. Dave Yost is the Attorney General. He has jurisdiction over every single one of these counties. So Mike O'Malley stating that he's not going to move forward does not mean that David Yost won't.
And I also think, and this is how I practice, and so I say this, if there's any defense attorneys out there or certainly listening, should you be outside of this county, and potentially have a case. I think given this new territory, it's really important to understand our role as defense attorneys to be an advocate very early on. That's certainly my policy. I try to, while I understand we're adversarial in the process, I think particularly in this context, there is a lot of room and place for conversation with the prosecutors in your county, if you will. Why is your case not a case that could sustain a conviction? Why is your case, what are the mitigating factors in your case that don't make yours really suitable for prosecution? That may be kind of not normally how some defense attorneys think. I actually usually think like that because I think the most success you can have is certainly on the front end potentially and at the trial level, not later on. But I just say that to really think about that where you don't know and you're in one of those 87 counties, I think there is a real opportunity and obligation for conversation with opposing counsel should you be a defense attorney and should you potentially have one of these clients.
Thank you. So let's move on to the next question. So one of the kind of themes that's been presented post-Dobbs and in anticipation of this symposium here today is people are wondering how their actions or their involvement could be seen as, they're using the word complicity, right? So we've heard what's aiding and abetting, what's complicity, and so forth. Even if it's not in direct contravention of law, can you explain to our audience what complicity is?
Sure, I'll take this one. So up here we have the elements to complicity: solicit or procure, conspire with another. Number 2 is aiding and abet and cause an innocent person or irresponsible person to commit an offense. I think one of the important things to really consider with complicity is any kind of assertion or belief that you aren't the principal offender doesn't really matter at all. I'm going to say that in really layman's terms. It's no defense, and also just know that as a complicitor, even if you aren't the principal offender, principal being said in another way as the main offender, that you could, if found to be guilty beyond a reasonable doubt, be punished as if you were the principal offender. So that's one really, I think, important thing to think about with respect to complicity. Specifically on aiding and abetting, assisting or facilitating the commission of a crime or to promote its accomplishment. I think important to remember that supporting, assisting, it can be encouraged. It can be that you facilitated, you verbally encouraged. Also, really important to remember that while mere presence isn't enough, I can tell you that presence and staying in the room and not leaving in the room could certainly be inferred and interpreted as if you had the same intent as everyone in the room. So the mere presence exception really is more for a bystander on the street corner than it is potentially for a nurse in a room that doesn't leave the room. So I think those are some, from my perspective, Ian, some high-level points to really think about with respect to complicity. I'm sure my panelists have some other weigh-ins on that.
I would just say I think it's really important to understand and remember that intent is so important. And when you're looking at complicity, so what is the criminal intent requirement within this context? So if we define intent, I think there's a number of ways to define intent, but we look at it as the common purpose among two people to commit a crime. So when Diane's talking about, standing in the same room, and I would agree with her that mere presence is certainly not enough. But I think if somebody were to suggest that, I was just there and I didn't know what was going on, I think remember the fact that prosecutors are going to utilize both direct and circumstantial evidence to determine what your intent was and what your involvement was. So an example that, we've been ruminating over a ton of different examples, and again, we don't know the answer to any of these questions, but something I think that's been thrown at me that I keep thinking about is if a patient were to order a Lyft or an Uber to go to an appointment, to hopefully their intention was to get an abortion. If they were to share with that Uber driver what their intention was and where they were going, and it turned out that it was actually not legal for them to obtain that abortion for one reason or another, is that Uber driver do they have a shared intent if they know that they are taking them to that appointment and it's illegal to obtain that abortion and they ultimately obtain that abortion? These are such kind of general questions and we don't know the answer to them, but to give you an example of where, mere presence may not be enough, but if they're made aware of something like that and they continue to carry out that assistance, if you will, I think these are just things to be thinking of as we continue to, navigate through this process, that the intent must be there. So, I would generally say the less questions asked, the better in situations like this. And I think, we were talking a little bit about this earlier with Dr. Romanos, but there's things that we think about as defense attorneys that we think of as second nature, offering information, asking questions, and quite literally not asking any questions and keeping things as basic as possible can sometimes be best practices in situations like this.
And I think to the point, when we're talking about intent or mens rea, all to say what is in someone's mind, all of us are thinking, well, how do you really know what someone's thinking, right? And under the law, one of the things that that is really important to realize is it's not just direct, but circumstantial evidence that can be used. And so I would go back to this Lyft driver analogy. What if the Lyft driver is asking lots of questions? Have you already tried to get one? Where do you live? How far along are you? And then let's just say, extending the hypothetical, the individual goes inside and then the Lyft driver on their own accord decides to wait so that they can do a return drive home. Those kind of things, the questions, the waiting, that circumstantially could really be used to prove intent, and then there's an issue under complicity. So it's important to really think about the direct and also circumstantial evidence when thinking about your intent. It's not just what someone says. They don't have to say, I intend to do X. It's much more than that. What is their behavior? What did they do? What do all of those things say that they were thinking?
So before I kind of move on to the next question, which is more kind of patient-based, as I hear you talking about what could be, my question is, how are we going to find out what is, right? How are we going to have these questions answered? And so really, short of the legislature coming out and saying this is fine and this is not, within the law, how do we really define and come back sometime, 6 months down the road with answers?
I think it's when the first case is filed, when the first prosecution is out there. I think that's how we generally define the law, is through the case law, and to see what people are going to try to do with the laws and what will stick and what won't stick. But I think it's going to be this navigation of these new waters that, when we were discussing this, I said, I kind of have more questions than I have answers. So when we're coming through here, we're all sitting here navigating through these brand new waters. And I think until a prosecution is filed, we're not going to have a clear answer.
Okay. And as a follow-up, Ian, I think really we're not going to have a clear answer until the first jury makes a verdict, because we're not only going to know what prosecutions are considering, to be a violation under law, but we're then going to know what jurors are thinking and how they are interpreting the laws and the facts and the evidence before them. So it's probably going to be longer than 6 months, as we know how these cases go.
And then the appeals.
That's
and
for
then,
sure.
I mean,
and then potentially 100%.
It's going to be a while.
Yeah.
So it would be fair for me to say, because we know that the same facts can be presented to one jury in one county, maybe get a result, same facts to another county, totally different results.
Or within the same county.
Right.
Yep.
True enough.
Jury.
True enough. So I thank you for that. So the next kind of set of questions deals with more patient focus. And a lot of questions have come in the last couple of weeks as to, if I'm approached by law enforcement, what are my rights? Now, again, I just want to remind the audience, this is an educational symposium. This is the law. This is not a directive as to what to do or not to do, but these are your constitutional rights, and that's why our panelists are here today, to educate on what those rights are. And so, again, law enforcement approaches a patient or a caregiver or a social worker, whatever it may be, and they say, hey, I've got some questions for you.
Yeah, so I think, and we've all talked about this too, it's, I think a bizarre conversation that we didn't think we'd be having with a number of healthcare professionals, but here we are. So it's important that everybody understand that we as citizens have Miranda rights. So what does that mean? It means that the Fifth Amendment requires law enforcement officials to advise suspects of their right to remain silent, their right to obtain counsel, and this all comes into play when you're in custody. So the general question that begs is, what does it mean to be in custody? So if you are, there's a number of different ways to figure that out. I think the legal inquiry is looking at the circumstances and evaluating those circumstances. Would a reasonable person in that position feel as though they are subject to an interrogation? So as a general person, what are you looking for, right? So if you are sitting there and you're being questioned by law enforcement and you have gone past security to get to the room in which you're in, is that door locked? Did somebody have to use a key card to get in or out of that room? Are you in there alone for a period of time and no one's coming back in or out of the room? Does it feel as though potentially you are on camera? Are you being recorded? There's always that movie scene where there's like bright lights, which it feels like right now I'm being interrogated, and there's people, and the law enforcement's coming back in and out, and they're asking questions, and they're banging their hand on the table. It may not look like that. So keep in mind that you could be in a situation where you are being very casually asked questions by an officer or an agent from the Department of Health or the pharmacy board, and they're asking you questions, and it may just feel like you're having a very casual conversation. Well, as Ian mentioned, we are not here to advise, but I think it is our duty as defense attorneys to let you know that there is no casual conversation with law enforcement, and it is important to understand that you have rights and that the trigger word is, I want a lawyer. And that should and likely will cease conversation. So if you are not interested in having a conversation with law enforcement, you want that conversation, so to speak, to stop, and you want to speak with counsel, that is what you need to say. You not only have a right to say that, but it is likely, until you can ascertain the gravity of the situation or what it is that person is investigating, it is likely the right thing to say to get your hands around it, speak with counsel. And then if you want to further that conversation, obviously that's your right to do so. I think too, oftentimes, because this, as Ian just mentioned, we don't know what these cases are going to look like. We don't know if the first case is going to be a patient, if it's going to be a provider, if it's going to be a volunteer. We don't know, and maybe we never get there, and that's a whole nother situation. But if we do get there, I think it's important that everybody involved in this process not only know their rights, but know how to invoke those rights. It's important to understand that if you are in fact in an interrogation or you are being questioned and they have not advised you of your Miranda rights, which is what's on this form here, you likely would be given a form to read, review your rights, and sign off that you've been advised of your Miranda rights. You may be in a situation where you have not been advised of your Miranda rights. That does not mean they have not been triggered. We've come across tons of cases in different contexts where somebody is sitting in what would absolutely be considered an interrogation by every case in the book, and they are not advised of their Miranda rights. You absolutely have the right to and should ask for a lawyer and cease questioning at that point, even if you have not been advised of your Miranda rights. So that's, again, something just to keep in mind.
Perfect.
And
Go ahead.
I'm sorry, I want to be sure to address two things. One is, anyone that's in this situation that thinks, but I have nothing to hide, I've done nothing wrong, why wouldn't I just go ahead? And I just want to really talk about that for a second. That's still best practice, and I know we're not here to give advice, right? But really think about it. None of us do our best under extreme moments of stress. Also, if you're likely to be in this situation within, a detective's office, you probably don't have a JD. And when you think that you've done nothing wrong, the truth is that you don't know every element to every offense which you perhaps might be prosecuted for. So I do want to distill any myth that this lack of cooperation infers that you have something to hide. It doesn't. It shouldn't. We need to get rid of that myth. And also, to that end, should you be told told, well, if you ask for an attorney, things are going to go worse for you, or, if you don't have anything to hide, why shouldn't you, just talk now? Again, it's not about whether you have anything to hide or not. It's really thinking like a marathon. This isn't a sprint. And you have a right to counsel. We all have a right to counsel. And so simply invoking your right, separate and divorce that from whether or not you believe you have anything to hide.
Thank you. Jen, from the prosecutor's perspective, as you heard Maddie say, there's no such thing as a casual conversation with law enforcement. Within this context, agree, disagree?
I would like to disagree, but no. No, in this context, she's absolutely correct. I think, and as you know, we've had conversations, and I think earlier on it was said in the forefront, have your attorney talk to the prosecutor and have that conversation. I think Diane maybe pointed that out. And that is a much more fruitful conversation, I think, than a casual conversation with law enforcement.
Thank you. So before I get to Becky's questions here, just two quick questions. One about electronic communications for a moment. And the question is, if someone's concerned about their data, their cell phones, their emails, they had a patient, it's a provider, they had a patient seeking an abortion, can they just delete the conversation on their phone? So basically, you're communicating, or you're driving, or you may be involved in the process as we're trying to figure it out here. You're approached, you find out there might be an investigation, or you're worried that you might find yourself in an investigation. The question is, can you just delete that evidence? Not only physically is it able to do that, but in theory from a prosecutor's and a defense lawyer's perspective.
No. No, in fact, go the opposite, right? Take lots of steps to preserve the evidence. And, and I say this about text messages. We all understand that there's the server, there's the cloud, but, screenshots of text messages, right? I think just really be smart about things. And going back to this circumstantial evidence that we talked about when we were talking about complicity, deleting things, right? It certainly that behavior indicates that you're intending something without saying it. So don't do it. Don't do it. Don't ask others to do it. And certainly I would even say, really protect yourself in that way. There's no wiping of phones, emails. Don't delete an email and then delete the deleted emails. Just best practice is really to know that everything is there and to embrace that. And if you think for some reason, a text message is a certain way, I'd even screenshot it just so I have that safety net.
Perfect. Jen, from a prosecutor's perspective?
You don't want additional charges of tampering.
Okay. Well,
I mean, bottom line, everything is recoverable somehow, one way or another, especially in this day and age of technology.
And oftentimes we see those in the criminal cases. There's the underlying offense, and then there's the aftermath of it, the cover-up, as they say. So thank you for the advice on that. We're going to go to Becky, who's got questions from those online and also here in the audience.
Thank you. Yeah, we've got quite a few. Okay, so let's start. There are a couple people that have asked questions about what changed. They're confused about what life before the Dobbs decision looked like and what post-Dobbs is. What was the state of Ohio's law pre-Dobbs, and is that the heartbeat bill that you're talking about?
So you want me to? Sure. Well, so now we are restricted to that 6-week window, and it wasn't a 6-week window. That was it was previously I believe it was 22 weeks. I don't want to misspeak, but it was 22 weeks where you could obtain an abortion. But now we're into that 6-week window, and again, that's really a 4-week window. And there are other things that must be done as well for that. You've got to do, as we said, the method of determining the presence of the fetal heartbeat. There's that. And then if you are going to go with one of the exceptions, and there's only one exception in Ohio, and that's for the life of the mother or risk of substantial and irreversible impairment of a major bodily function. So there's no exception for rape, incest, or mental health of the woman carrying the child. The only exception is that. And so if you're a physician and you do find that there is one of these exceptions that applies, or this exception applies, you have to specify in writing what the medical condition is, and you have to place it in the record of the patient's file and maintain it for at least 7 years. And if you don't, you could be fined up to $20,000 for each failure to follow that. So we've got a much smaller window to obtain an abortion and other things that have to be followed in terms of if you are going to give an abortion with an exception.
A couple people have asked about, since Prosecutor O'Malley has said that he is not going to prosecute in Cuyahoga County, could an assistant prosecutor of his or her own volition prosecute in Cuyahoga County? And then a related question, if an assistant prosecutor can or can't, could the Attorney General for the state of Ohio come into Cuyahoga County and either initiate the prosecution or file a motion to change venue?
The Attorney General could. I do not believe an assistant prosecuting attorney would ever do that. Mike O'Malley's name is signed on all of the indictments, and to do so would be just absolutely wrong. But the Attorney General could come in and prosecute. Absolutely.
Okay, we have a couple of jurisdiction-related questions. So, and I'm going to simplify a couple of these into sort of really one. They want to go back to understanding. If you have a woman inside of Ohio who is seeking an abortion, and you have somebody from outside of Ohio who is assisting in transporting that person, this came in after your discussion, transporting the woman outside of Ohio, okay? Is there potential liability for the person who's doing the transporting, even if they're not a resident of this state?
Well, I think part of the question begs the question, which is the state that they're going to, and I apologize if you said this, but is the state that they're going to, is abortion legal in that state?
Yeah, in the state that they're going to, but let's say, I think under the scenarios that I've been reading is the helper, the person who's assisting, is coming from a third state. So it's illegal in the state where the helper's coming. It's illegal in Ohio where the woman who's seeking the abortion is from. Both people go to a state where it's legal.
Wow.
I don't like that one, but
I don't think we like any of them.
I'm just kidding. I think what I would say is it all comes back to a few main points. Number one, you need to look at, so first of all, the person does not have to be a resident of the state of Ohio for a jurisdiction to attach. I think that's most important that we clear that up right away. So you could be just like somebody, I mean, you know, we have clients all the time that come in from out of state, they commit a crime in the state of Ohio, and it's charged in the state of Ohio. So that's first and foremost. And then I think second of all, this is really this is where all the conversation is right now, is if somebody is assisting somebody to procure an abortion in a state that is legal, I think for many aspects of jurisdiction, that kind of takes the legs out of jurisdiction in Ohio, because it is legal in that state that they are going to. However, as Jen pointed out, you know, number 4 is really where my mind is going as far as the question, because if somebody in, Mara, if you want to stick to number 4, if you don't mind,
please?
if somebody is failing to or omitting to perform a legal duty imposed by the state of Ohio, and that failure to do so is therefore affecting the interests of a person, which I think is where Ohio is potentially heading, as you know, regarding a fetus, that I think that could implicate somebody, especially when we get to complicity and how they may be attempting to or complicit in helping that person to procure that abortion. So again, I don't think that we're in a position at this point to give any firm answers on that, and I hate that, but I think that at least I'm glad people are thinking about it that way. But if I would be thinking about it in the sense of, you know, Mike O'Malley has said he is not going to prosecute these cases. We know that a number of prosecutors are dying to prosecute these cases, and if they want to prosecute that case, they're gonna implicate every section of jurisdiction that they can, and they're gonna see what sticks. They're gonna throw it all up there, and they're gonna hope that it works. So, you know, again, this is not meant to scare anybody, but I think it's something that people need to be thinking about.
Well, and also I think to that point, as we all know, if you indicting one person versus indicting 3 or 4, if you indict 3 or 4, your potential for cooperators to help prove your case is much greater than if you just go after one. So I just say that in terms of numbers is, again, and it circles back to what Jen was talking about prosecutorial discretion is, a prosecutor that does charge one of these cases is going to want to be able to prove it. And that cooperators are always helpful in that way. So I just mentioned it as something to think about.
And the section shall be liberally construed, consistent with constitutional limitations, to allow this state the broadest possible jurisdiction. So something to keep in mind.
Okay, keeping the heat on the prosecutors, where do you think a prosecutor is likely to draw the line between what's sharing information or free speech and complicity?
It would have to be in context. I'm sorry. That it's a little too broad at this point.
So that's going to be a consistent answer to many of these. Okay, here's a different question, but related. Surrogacy contracts. Let's think about surrogacy contracts. They often include provisions regarding the circumstances under which the carrier can or would abort. Since 2015, surrogacy contracts have routinely included provisions that say if the abortion cannot occur in the state of Ohio, the carrier, an Ohio resident, will travel to a state where the abortion can be legally performed. Do you see any potential liability for including this language in a contract executed in Ohio or outside of Ohio involving an Ohio resident?
Yeah, it goes back to the jurisdiction.
Yeah, I think that gets back to jurisdiction. I think, again, if they, I am certainly not a contract lawyer, so I don't want to speak to the efficacy of that, but I think that allowing someone to travel to a state in which it is legal as of now, as of, the state of the law at this moment, especially assuming those states, a lot of our neighboring states are teetering at this point as to where they're going. I know panel 3 can talk a lot more about that, but so knowing what the state of the law is in those states, I think that, again, assuming they're not trying to stretch jurisdiction farther than probably what's allowed at the moment, if they are traveling to a state in which it is legal, it doesn't, tip off anything in my mind as far as a jurisdictional, I don't know how Ohio would attach, I guess, at that point, assuming things stay as is.
I agree.
Agree.
Okay, great. Another question. How would law enforcement and prosecutors even know about a possible offense?
We've been discussing this quite a bit and trying to figure that out just with HIPAA laws and whatnot, but the Department of Health could be the entity to go in and ask if somebody were to, again, call in and say, I have a tip that Dr. Romanos is doing something, wrong and has performed this abortion. It would tick the Department of Health to then go in and investigate and ask for files and ask for different things, which could then give the possible evidence necessary.
I think circumstantial evidence too. A lot of this is going to come down to, Jordan was talking a lot about, self-administered abortions. We have cases all the time where a tip comes in, somebody is alleging that, somebody has committed an offense, and if they have, enough probable cause to do so based on a number of other, factors and evidence that may come in. If we've seen cases throughout the country where a search warrant of a person's phone detailing research they've done or an order placed for prescription or medications can lead them to a place where they, the circumstantial evidence can lead to a number of different things that I think people need to at least be aware of as it relates to, as Diane mentioned, if you don't want someone to know about it, don't type it in your phone.
There is also a statute that does allow accusation by affidavit by a private citizen. I've been a prosecutor for about 22 years now, and I've very seldom seen it, but it happens every once in a while, and you don't know under these circumstances with people and where they're going. Are they going to try to do the affidavit by a private citizen as well? But then again, it goes back into the prosecutorial discretion and what evidence could be found. But that is another area to be aware of.
Could data collected on third-party databases like Flow, which is an app that I think some women use to track their menstruation, could data like that be used to prosecute individuals?
Sure.
Yeah.
Absolutely.
And I guess.
It would have to be secured properly. I
Right.
think there's that. We should say, right, you can't get a search warrant without probable cause. Understand, though, probable cause is a much lower burden of proof than proof beyond a reasonable doubt. So it doesn't take much. Let's be clear about what probable cause constitutes. It could certainly be enough from, a tip that is reliable or found to be reliable in some way. Yes, but it needs to be obtained properly, right, with probable cause, search warrants, but certainly search warrants to get data from the cloud or Facebook or Messenger or Snapchat, all of those kind of things. Those are all within the common practice and use of the government, the state, and that kind of data can be quickly obtained.
With further factors, though. I mean, it's not just, I don't think that any prosecutor would go in and say, hey, I'd like all of the information from Flo. They wouldn't get it. There would have to be other factors in order to establish the need, although probable cause is a lesser burden, but to establish that need in order to get it. So it wouldn't just be that alone.
Let me just add to the question, just to make clear, because we're hearing terms like probable cause and so forth. You're not suggesting that that standard is just for kind of general Ohio citizen to determine. This is strictly law enforcement making that determination. Is that correct?
That is correct.
Okay, because I just want to make sure we're not talking about the apps turning stuff over or people going and getting it and extracting it and making a decision as to whether or not something should be prosecuted. This would be a case, and then therefore the investigation would be a search for evidence. Is that kind of how it goes, Jen?
Correct.
Okay, all right. I just wanted to give some clarity on that.
Is giving money to an abortion fund or a defense fund complicity?
I feel like I've been asked that like 12 times
Yeah,
last
yeah,
week.
I think we've really answered that. It goes back to the jurisdictional issue, right? If you're funding an organization within Ohio right now, and they do certain practices which certainly don't seem to be covered under the law, which goes back to really where Jen started, certainly. But I think it's a lot of dominoes to fall. But I think those questions really go back to the jurisdiction and the law, where we really began.
Let me, Becky, if I may pipe in, Diane, just to kind of continue that question. The question was just in general, is it legal or illegal to get money? But if you're giving to an organization that has many facets, they do a lot of different things, okay? Does that change the game for you a little bit? So you have, okay.
For sure. And also, it goes back to this intent. All to the point, it was well organized, this order of speech here. But, the intent, right? Are you giving it to an organization that right, is it with intention breaking the current law? But to your point, Ian, if this organization is doing a lot of different other procedures and practices and gives general health care, let's just say that, then certainly no. I think it really goes to the circumstances of each and every case. Back to the intent, the law, jurisdiction, there's so many elements there with that question, I think. But yes. Yeah.
Thank you, thank you.
To a last question, to our criminal defense attorney, question is, what do you think some of the most likely defenses to these criminal charges would be?
I think there's going to be a really big, I think when the first case comes, I think that there's going to be a really big question around the causation and the evidence, and whether or not the state of Ohio is going to have the evidence necessary to correlate to what actually caused the end of that pregnancy. Because we've seen, in a more simple, straightforward abortion case, if somebody were to go and obtain an abortion and it's at a clinic, I think those cases are a little bit more straightforward. Did they break the law? Were they within the 6-week period? All of that. But I think we've seen, I saw a statistic the other day from the National Association of Pregnant Women that there's been 38 states that have prosecuted cases where kind of what they consider to be like pregnancy outcomes. So criminalizing a miscarriage where, it's the state's position at that point. They are prosecuting someone determining that alleging that they have ended that pregnancy. Jordan mentioned the self-administered, medicated abortion. If they cannot make that causal link between how that pregnancy ended and whether or not it was actually the act of the patient, let's say, I think that's going to be difficult. So I think challenging a state's case both on the causal link there, I think really challenging the experts that they're going to put forward. For instance, law enforcement officers are not qualified to talk about scientific causation. They are not qualified to talk about how and when and in what fashion an abortion can or cannot occur. So if a state is trying to move forward, if a prosecutor's office is trying to move forward on a case and their only witness is a law enforcement officer, that needs to be challenged immediately. We need to be bringing in experts, OBGYNs, forensic pathologists, to talk about the actual, causation and the science behind what did occur. It's not just as simple as a time period, and it's important that as defense attorneys, we are, this first case, when it comes, that we are actively and aggressively pursuing experts to come in and talk about the science behind this, and looking to people like Dr. Romanos and Dr. Burkons to actually educate the public and educate that jury about what that case looks like.
Yeah, I know time, but I think I can answer this question from literally personal experience of the case I tried earlier this year. I represented Dr. William Husel, an ICU intensivist who was charged with 14 counts of murder for overprescribing fentanyl during palliative care, or what we all call comfort care. And as we look at the statute, and I'm keeping it from a high level, it's first intent, and then the jury must consider causation. I will tell you that I argued for 10 plus weeks of trial that case was about intent or lack thereof, because the question was whether my client intended to hasten the death. And then there was a second issue of causation. I can tell you that I spent a lot of time with those jurors afterwards. My client was acquitted of all 14 counts of murder. I spent a lot of time with the jurors afterwards, and the jurors said they never even deliberated causation because they never found the intent. So for me, with respect to these cases, it will be on the intent, which is why it's so important to think about direct evidence, i.e. what someone might just say, and then circumstantial evidence. But for me, that it's the intent that's going to be the meat on the bone when the first case comes.
I got handed one last question, which is related to this. What do you think about juror nullification? Will jurors in your respective communities, do you think that they will enforce the law?
Can we pull that map back up?
Yeah, right.
Yeah,
Diane, what do you think?
I do, actually, even when they don't want to, because let's not forget about voir dire. And also, people want to do the right thing. And the truth is that the whole voir dire process that we do as defense attorneys and prosecutors is, what basic question is, will you follow the law? And in a case like this, both sides would heavily voir dire on, even if you don't like the law. And I will tell you, in the Husel case, hate to go back to it, but there is a lot of people in this country that believe in euthanasia. And the prosecutors really, really voir dired heavily in the Husel case about beliefs in euthanasia and comfort care. Because in the end, we all recognize that we might have some jurors that believe in euthanasia, but still needed to follow the law as it is in Ohio with respect to intent. So yes, I think jurors will follow the law because it is truly what they promised to do. And it's why I love our jury system. Jurors do just that.
Perfect. How are we on time? Are we good? All right. Well, listen, I'd like to thank you all for being here today. And please give our panel a hand. All right. Thanks, everyone, for being here for our third panel here today. To the far left side of the table, depending on which way you're looking, I suppose, we have Jesse Hill. In the middle is Sarah Inskeep, and closest to me is Colette Ngana, and they are here to talk about where are we going, where are we at this point. So thank you, the three of you, for being here today. And Jesse, I'm going to start with you right out the gate. Can you give us an overview of how Ohio law is currently restricting abortion?
Yeah, sure. Thank you. And I'm going to give a little bit of an overview of what the provisions, a little more in-depth overview of what the provisions of the law that's currently in effect say. So the so-called heartbeat ban is a ban on abortion after fetal cardiac activity can be detected. So we call it the 6-week ban a lot of times because that occurs right around 6 weeks LMP, right, which is actually 4 weeks after conception. But it's really keyed to whether or not the fetal cardiac activity is detected or not. So it's not a specific time cutoff. One thing to know right off the bat is that Ohio law doesn't follow medicine, so the definitions of things in Ohio law are not going to track the medical definitions that you learned about in the first panel. So the definition of an abortion under Ohio law is the purposeful, as somebody said earlier, is the purposeful termination of a human pregnancy with an intention other than to produce a live birth or remove a dead fetus. Pregnancy, however, is defined as beginning at fertilization in Ohio law. So that would mean that under Ohio law, ectopic pregnancies
which Dr. Romanos was talking about, do qualify as quote-unquote abortions. However, the law that's in effect, the 6-week ban, explicitly excludes ectopic pregnancies. So it says it doesn't apply to those. So those, and the other thing that you need to know about the Ohio law is that it exempts, and I think this has been kind of discussed, but it exempts the pregnant person from any criminal or other consequences. So the patient themselves cannot be prosecuted under the law. The law carries felony penalties and the possibility of medical discipline, right? You can lose your medical license. So while it's great that there is at least one county prosecutor that's not going to prosecute, I think the fourth panel is going to talk more about the other kinds of consequences that can come out of this. And then also, there is this vague medical exception language, which again was discussed earlier, that the pregnancy can, or the abortion can be performed to save the life or prevent the serious risk of the substantial and irreversible impairment of a major bodily function, which again is not how doctors talk. It's not even really how good lawyers talk. I don't know who talks that way, but doesn't map very clearly on to medical practice in any real sense. The other key aspect of the law, and this was because of clarifying regulations that were put out after the law went into effect, ODH put out some regulations that said that you have to perform the ultrasound essentially on the day of the procedure to determine if there is a fetal cardiac activity. However, you also have to perform it 24 hours ahead of time when the patient comes for the first visit, because there is this mandatory 24-hour waiting period under Ohio law.
Thank you, Jesse. Kind of the next set of questions still are with you, Jesse, if you don't mind. What legal requirements must be met for someone to provide an abortion in Ohio?
Yeah, so there were other underlying or pre-existing requirements before this law went into effect, and so those are still in effect. So there is this, you have to come 24 hours ahead of time. This has been the case since before June, that you have to come for your first appointment to the clinic 24 hours before the abortion procedure. You have to go through an informed consent process. You have to get an ultrasound, and the person who performs the ultrasound has to try to detect whether or not there is fetal cardiac activity. Now, before this ban went into effect, if they detected cardiac activity, they just had to tell the patient, offer the opportunity to see or hear it if the patient wanted to, and then give them this information about likelihood of carrying a pregnancy to term. So now, if you discover fetal cardiac activity at that day one first appointment, the patient goes home and has to go somewhere else to get care, has to go out of state. And then the other thing is that Ohio has restrictions on medication abortion that go beyond what apply in other states. So in Ohio, the medication for the medication abortion has to be picked up in the clinic. It cannot be picked up at a pharmacy or mailed to the patient or anything like that, although that is the case in some other states that can be done. So, and then other than that, all the rules that apply to, procedural abortion also apply to medication abortion because it is an abortion, so the abortion rules apply.
Great, thank you. So there's a legal challenge in Ohio to the 6-week, the heartbeat abortion. If you could tell us what role you play in it and kind of what the status of that challenge is, that legal challenge here in Ohio.
Yeah, so I am one of the attorneys on the legal team that is currently challenging the 6-week, as we call it, abortion ban in Ohio under the Ohio Constitution. So, and I'll just take a step back and say in 2019, I was also part of the legal team when the ban first passed. That went into federal court. We argued in federal court that the ban was clearly unconstitutional under existing law, which it obviously was. The court agreed and put, preliminarily enjoined the law immediately. And then within a few weeks, we filed another motion asking for judgment on the pleadings because there were really no factual issues, and it was so clear we didn't need a trial, the judge could just rule. And the judge did not rule on that motion from 2019. And then the judge officially stayed the case in 2021. So put the case on hold for those who are not lawyers. And then in 2022, in June, when the Dobbs decision came down, which said there is no federal constitutional right to an abortion, the AG, Attorney General Yost, immediately within minutes filed a motion to lift the injunction that had been in place since 2019. And the judge gave us a couple hours to respond and then lifted the motion at 6 o'clock that day, or lifted the injunction. So the following Wednesday, June 29th, we filed our case directly in the Ohio Supreme Court, asking for a writ of mandamus, which is something that the Ohio Supreme Court has original jurisdiction over. We also asked the court...
Let me stop you. What is a writ of mandamus?
Well, it's right. It's one of these legal terms that even like some of us who are lawyers might not be super familiar with. I've had to learn a lot in this process. But it's basically an order directing a government official to do something under the law. So in this case, and this is... Our case in the Ohio Supreme Court was asking for an order to the Attorney General and the county prosecutors to conform their conduct to the Ohio Constitution and to abide by pre-existing law that existed before the heartbeat, quote-unquote, heartbeat ban was passed. So, and there have been other cases where the Ohio Supreme Court has taken original jurisdiction over constitutional challenges that are styled this way as a request for an order to conform to the state constitution. So we argue in that case that the 6-week ban is unconstitutional under the Ohio Constitution's equivalence of the Due Process Clause and the Equal Protection Clause. The Ohio Supreme Court did not grant our request for emergency relief, which we asked for, just an emergency stay on the law. However, the Ohio Supreme Court has not yet decided whether it's going to take the case. The state still has a few more days to respond to our motion, and then we expect the court will rule, after that, but obviously we don't know exactly when.
Very good. Thank you. I'm going to open this question up. I've got a couple more questions for you, Jesse, but I'd like to open this up to the panel real quick. It seems we have a lot of questions coming in with who's driving kind of the legal strategy here. From both sides, you were talking about bringing a motion and the state and so forth. Who's driving legal strategy for what's next in Ohio? And people want to know how they can get involved. And we're sitting here talking, you're talking as a lawyer, but also the public. And we have a lot of people watching us on the computer. So how do people get involved with what's going on here in setting policy in Ohio?
Wow.
Strategy, I should say.
So strategy. I am in this litigation, although one of my jobs is as a law professor at Case Western. I am in this litigation. I serve as a volunteer attorney or cooperating attorney for the ACLU of Ohio. In that capacity, we also are working closely with National ACLU Reproductive Freedom Project, as well as National Planned Parenthood Federation of America attorneys. And we are working also with a law firm out of New York and DC called Wilmer Hale. And they are together actually, I felt very strongly from the beginning of the litigation that it had to be driven by folks in the state. So the attorneys in the state are really driving strategy and driving the litigation. So me and the ACLU of Ohio. But yeah, that's obviously always in consultation with the clients who are the abortion providers in the state. Several abortion providers in the state, I should say. So The question of how to get involved as lawyers, there's all kinds of opportunities. I mean, one of them is to get involved in the criminal defense side and to coordinate, which Ian's firm is helping to coordinate or is coordinating for future needs. There is also an effort, and people can reach out to me. There's an effort to coordinate folks for non-criminal legal needs in various other areas, sort of on the civil side. As well. And then, we often also, we're putting together amicus briefs and so on. So there are opportunities on that front too. If you're not a lawyer, that is less my realm. Maybe other folks want to talk about that, but there's plenty of opportunities.
Sarah?
Sure. So in addition to the litigation and legal strategy, there's a pretty robust advocacy and education accompaniment to the work that's happening in Ohio with reproductive health rights and justice organizations or movement more broadly in the state. You could simply look at the front of your handout and see many of the partners with their logos listed here. Look up their website and get involved with them. If there's a specific angle or interest or identity or what have you that relates to you or compels you to get involved in this work, as you can see, many of us drove from all over the state, came together within 2 weeks to join efforts to move this work forward. So I would say in addition to the beautiful, brilliant legal strategy that is so desperately needed in the state, that needs to be coupled with really robust advocacy efforts that my organization and the organization that Colette and so many others are supporting that work with. So it's really a multi-pronged strategy. We can't just have the legal work happening in a silo. It needs to be happening with the folks who, one, are going to the clinics or are needing care, in addition to the advocates and the activists that are joining us in the streets and in town halls and in the State House, being really in lockstep. So I would just say the easiest way to look to that is just look to some of the organizations and their logos at the front, but I'm not sure if Colette had anything else to add there.
Not too much to add, but just sort of agreeing that, I'm not sort of on the strategizing side of the legal aspects of what's happening, but I am from preterm, so we are an independent clinic, and so I'm sort of focused on access and our patients right now. So, one way you can get involved is that we also have really great sort of advocates that work with us at preterm that help escort patients into the clinic to kind of protect them from protesters and the effects of being I don't know the right word here, many words.
Harassed.
Harassed, thank you, by protesters outside of clinics. Another level to this, and I know it's sort of a little bit scary coming off of that panel that we just had, but if you're not able to kind of volunteer your time or be somewhere, money is a really great way to support these efforts, right? So we do have abortion funds in Ohio. We have national level abortion funds, but really sort of giving money to your local clinics, giving money to organizations like the ones that are sponsoring this program are going to really, really help us do this work.
Thanks, Colette. And I'm going to go back to one of the questions from the last panel, which was, giving money and so forth, and you brought that up. And so my question just very specifically is it fair to say that the agencies that you represent and some of the others that are there on the cover page not only perform procedures, but there's a lot that these agencies do, education, as you said, and so forth. So I just want to kind of see what the scope of your agencies are in light of our last panel.
Oh, sorry. So this can range from something that looks like an information sharing session around self-managed abortion that young people are leading. That's a pretty substantial effort that's happening in Ohio and across the country, is just sharing information that reduces legal risk, but also puts information in the hands of everyday people who need it most. And our peer-to-peer kind of model of education is most effective. So folks who are not in this room and may never see this recording, but are receiving educational trainings from advocacy and educational organizations that target target those groups is a wonderful way in which we're seeing a lot of efforts being, kind of advanced. I would say in addition to that, in the past, there's been a lot of effort to bring folks to come and testify at the State House or even at City Council hearings on any number of policies that have previously moved that are now law, unfortunately, are currently pending in our state legislature and are, of course, going to be advancing at pretty rapid rates at the local level as well. That is something that I've spent a lot of my career doing, is not only participating and testifying, but also recruiting folks who are patients, are storytellers, are academics, are providers, what have you, just advocates to come in and feel comfortable and safe and confident sharing their story and sharing why they oppose or want to advance any sort of policy. Those are kind of the main ways in which I see it, but I'm sure there's many others that preterm and other funds and clinics probably advance.
Thanks, Sarah. Colette?
Sure. As I mentioned before, I am on the board of directors at Preterm, and so we're an independent clinic here in Cleveland. And so we tend to work with other organizations to do educational opportunities and other sort of outreach. But we also have folks at the clinic who do this outreach work as well. So one of the roles of our clinic, obviously, is to make sure that our patients have access to abortion care. That is one of our primary goals as an abortion clinic, which is a very difficult task for us right now because we can only provide abortions up to 6 weeks. So access is very, very low. So in terms of our role, we're working with other organizations that are helping with referral programs, who are helping with funding. We also, as Sarah said, we sort of support programs that help bolster opportunities for people to tell their stories. Storytelling is a very important aspect of this work. So again, our primary goal is to help ensure that people have access to the reproductive care that they need, but we also work with other organizations to ensure dissemination of proper information around reproductive choices that they have within the state and obviously at our clinic.
Very good. Thank you. Appreciate that. Jesse, I'm going to return back with 2 more questions for you. What sorts of issues are we seeing with the implementation of this law in Ohio now?
Yeah, I mean, I think a lot of the questions have already been coming up in the Q&A, so these are the things that we're hearing. I mean, one of the things is, again, this vaguely worded health exception or medical exception and what exactly qualifies. The statute does have a little bit of further specification. It says certain things do qualify, certain conditions, like one of them is preeclampsia, premature rupture of membranes. I mean, there are certain conditions that are called out, and then others that it says maybe qualify, like diabetes, multiple sclerosis, and then it explicitly says mental health does not qualify. And again, as one of the prior speakers mentioned, there's no rape or incest exception. So, I mean, there's just a lot of uncertainty about what does and doesn't qualify. And again, all of that has to be understood against the background of if you choose wrong, you're worried about a felony prosecution and conviction, right? And then I think the other big questions we're seeing are around this sort of traveling to other jurisdictions, what constitutes aiding and abetting in that context, and also what sorts of obligations do providers or people who come into contact with others have in terms of reporting, documentation, and so on. So there is a lot of vagueness here. I mean, there are some things where we've gotten a little more of a sense, and I think, again, if you're someone who is wondering about that, consulting directly with an attorney in a sort of privileged setting is the best way to get real clarity or good advice about that. But these are some of the big areas where the law is just creating a lot of headaches.
Thanks, Jesse. So we're talking, so far you've spoken about Ohio, but
Yeah.
what's kind of the status with the surrounding states, those that are touching Ohio?
Yeah, good. Oh, great question. So right now, West Virginia does not have abortion services. Kentucky and Indiana, Michigan and Pennsylvania do. And so Indiana is going to be coming back for a special legislative session in a few days, later this month, today, great. And they are expected to act to ban abortion completely and also to enact that as an emergency measure. So meaning that it goes into effect immediately. That's the expectation. I don't know how long Kentucky will hold on, hopefully Michigan and Pennsylvania there, but all of these, even these haven states, a lot depends on what's going to happen in the next election. Did I get the West Virginia thing wrong? I did. There are services now? Oh, they got to stay in the last week. I apologize, I'm not up to date. There are services now available in West Virginia as well. So really, Ohio is currently the most restricted state in its immediate surroundings, but we do expect that that could change, in the coming months. And I know Sarah's going to tell us that it could get worse in Ohio as well.
Thanks, Jesse, and perfect. Sarah, what is going on right now, pending policies, kind of the legislative landscape?
Yeah, sure. Jesse, you teed that up pretty well. But I too, kind of like your point about West Virginia, this is all happening so quickly, whether it's litigative or legislative. This is a revolving door and a lot's happening. And I think what is so great about something like this is that it is to hopefully put up the correct information and clear up any misinformation that even folks who are doing this work every single day can absolutely happen to, because all of this is meant to be difficult to follow and inaccessible. So it happens to all of us. So I'm going to talk a bit about the pending legislation in the state of Ohio. That's the work that I've been doing. I'm not an attorney, but I've followed state policy. And as we know, this General Assembly, which we're in the 134th General Assembly, for those of you who don't follow policy work as closely as I do, I'm glad for you. But we have a 2-year legislative cycle in Ohio, which is a little different than most states, frankly. We're in the second half of the General Assembly here in Ohio. And we've been on summer break, which typically for folks that are in this room or do policy work, that typically means a break. But unfortunately, we've had Dobbs happen, and there's been this fury of interest to move more extreme anti-abortion legislation. That's why we have states like Ohio or Indiana coming back for a special session, which there was definitely some moments throughout the last several weeks where we're like, is this going to happen in Ohio? We're not sure. But as we know, this legislature is outright hell-bent on completely outlawing abortion in the state. That's evident in many places. But what I'll talk about is what's currently pending and what we anticipate moving when the legislature returns in November. So we have several bills. I'll talk about 7 very briefly. I imagine there will be questions that'll come out of some of the remarks that we'll make here, and I can clarify that. But in the last 2 weeks, we had House Bill 704 that was just recently introduced by Rep. Click. This is a Personhood Act. The bill in its truest form is an outright abortion ban that seeks to define life at conception. There's lots of concerns, not just, of course, around the fact that this is an outright complete abortion ban, defining personhood at life and conception, that there are concerns around IVF and other forms of contraception. Just because the legislature is at rest doesn't mean that their staff and the Legislative Service Commission isn't busy working and that they can still kind of move bills. But we've had the bill introduction. We don't anticipate it moving in the coming weeks because, again, they're supposed to be at rest. But that bill is teed up and will absolutely start receiving hearings as soon as they come back in November. So that's bad. The other 2 bills that we were following quite closely leading up to the decision around Dobbs, which we knew was coming for some time, which I guess no one said that yet today. We all knew that this was coming. We'd been preparing for this moment, and so did the folks who are advancing the anti-abortion agenda in the state and across the nation, right? So we had things called trigger abortion bans. In Ohio, we have 2. Functionally, they're the same in how they're written. Those 2 bill numbers are House Bill 598 and Senate Bill 123. The bill that's advanced further is House Bill 598. It's further along in the legislative session, or legislative process, rather, but both of those bills seek to completely outlaw all abortion care in the state of Ohio. In the time in which we were talking about it, it was a hypothetical around the Supreme Court acting to overturn gut or change the Constitution around Roe, which has happened. Those bills have not passed. Again, right now, approximately up to 6 weeks, abortion is still legal and theoretically accessible depending on who you are. But what is important is that they're going to advance, we wholly expect either the trigger abortion bans or perhaps even this personhood bill or what's going to be at play when they return from summer break come November. There's been a lot of political appetite around the trigger abortion bans. They didn't get them as far as they would have liked before summer break, but they're perfectly teed up to move once they return. I'm going to grab my notes here. A few more that I'll note. As you may have heard, we also have House Bill 378, which is, we refer to it as like the Medical Misinformation Act, but what the bill seeks to do is require providers to lie to patients around the possibility of reversing a medication abortion by administering a drug or a hormone called progesterone. This has been widely debunked by lots of medical organizations. It's experimental at its core, and it's quite dangerous. But this is another bill seeking to regulate in misinform Ohioans and also possibly experiment them and force providers to lie. That bill also moved pretty early this year in the legislative process. We also had House Bill 480, which was modeled after Texas's Senate Bill 8, but then some. This is a bill that seeks to allow private citizens to bring along civil suits for anyone who aids and abets an abortion. I think there's a $10,000 fine and some other steep penalties, but this isn't a criminal case. This would be a civil charge, which is different in nature and will allow anyone, a neighbor, a politician, an Uber driver, what have you, to bring about a civil suit. And the state would actually incentivize it by saying, we'd give you $10,000 if you bring forth a case of this nature. That bill, I believe, has just been introduced and hasn't received any hearings. The last two bills that I'll just briefly cover are Senate Bill 304 and House Bill 421. Both of these bills are, in my opinion, a bit redundant, but the point of them is to just further regulate abortion care in the state. One is around I'm sorry, my notes are so long and there's so many bills. It's hard to keep track of them all. Around the clinical procedures and regulating medication abortion, which is absolutely like the next phase of all of this, is can folks travel and self-managing abortion? How are we going to further criminalize those things? And House Bill 421, again, is around requirements for ultrasounds and further regulating providers and how they administer and are required by the state to provide ultrasounds to patients. So as you can see, there's a whole host of bills. The last thing I'll note, which I know we'll talk a little bit more about, is that we're heading into a lame duck legislative session, and I'll talk a bit more depending on the impact of the election that we're currently in, how that will pan out in the state legislature. Sorry if that was extensive.
No, that's extremely helpful. I mean, it is what it is, right? So there's a lot to talk about. Thank you. And Colette, I'm going to turn to you and kind of talk about the social implications of these legal restrictions. And specifically, in your experience, what are the social implications of these laws that Sarah was referring to and Jesse was referring to? Kind of how's this playing out practically on the ground?
Sure. So I think that I'm going to start sort of talking about provider protections. All of these laws are focused on punishment, right? We don't have laws in place right now that really protect providers who want to do this work, who feel compelled to do this work. In the first panel session, Dr. Amato said that right now she's performing care, or the practice that she has right now doesn't go, with her conscience as a provider, right? And part of this is because we don't have protections for people who feel compelled to do abortion care, who feel compelled to help their friends get abortion care, right? So sort of thinking about what does it mean when the law is focused on penalizing people, putting them in jail potentially, fining them for doing this work, but we don't have anything really in place to help people who want to do this work because they feel it is ethical to do this. So that's one sort of potential implication, is what does this look like for providers who sort of fall outside of mainstream medicine, right? Our abortion care providers, as well as people who work in mainstream hospitals. And then again, as Sarah mentioned, sort of these laws that are coming into place or being proposed that allow civilians to advance sort of these legal restrictions, and we don't really have anything in place either to protect individuals from that harm as well. So that is one sort of implication, I think, of these laws, is that we don't have anything to counteract people who are going to be criminalized for this. Another thing that I think about is that, preterm is an educational facility as well. We do train resident physicians on how to do abortion care. And without that, again, since this is not care that is readily available in the educational sort of programs within mainstream hospitals, we are going to see a dip in the number of providers who have that type of experience, right? That full range of reproductive care. And so when we think about sort of the makeup of OB-GYN now, how are people going to know how to do abortion services if the facilities that train them are only able to perform care up to 6 weeks, right? So there's this idea of the provider protections that I think is really important to consider when we look at the implications of these laws.
Very good. Thank you. So I've got a question for kind of the entire panel as to ethics and ethical care. And Jesse, if you wouldn't mind, what is, as we see up here on the board, what is legal is not always what is ethical. Can you explain that?
I mean, I think that, right, I'll just start with that, and I think Colette is maybe really the expert here, but I think the law really sets up ethical dilemmas, right? And Dr. Romanos was talking about that by, forcing physicians to make a choice between, their ethical obligations to the patients, the oath that they took, and what is legally permitted and not permitted. And I think that, to some extent that has been a challenge with abortion restrictions all along, but now that we have such a draconian law that cuts off the ability to provide care so early, and with such limited exceptions, that I think it has just really made this set of conflicts come very much into the foreground.
Colette, last question for you before we go to Becky, and Becky's indicating we've got a whole stack of questions for the three of you. My question is this, and kind of dealing in the ethics line as Jesse, segue to you. Some state, county, and city governments, as you know, are advancing legal protections to those seeking or assisting in abortion care, even in the face of what some may say is inevitable and increased criminalization. The question is, what are some of the potential impacts of this inconsistent and kind of geographical patterning?
Yeah, so I think it's hard to say exactly what's going to happen, and so I'm just going to look at what we do know happens when access to healthcare is patterned by where you live. We have plenty of information on that historically. So, when you have patterned access and patterned sort of protections by, your zip code, you're going to have very different outcomes, from city to city, county to county, state to state. And that's part of what, if you have national level protections, helps sort of level that a little bit. And so what I think, especially in a city like Cleveland, that we already know that your geography, where you live, is tied so heavily to your health outcomes, right? That I think that we're just going to see these differences sort of increase, right? So I think that we're going to see that these patterns are going to follow what we already have established through sort of other means of systemic oppression, right, by race and class. So meaning people who are already marginalized and oppressed by our sort of current systems are going to be further sort of oppressed and are going to be the ones that probably don't have those types of protections. We also know that, like, historically and globally, that when we have these laws that restrict reproductive choice, right, they have intergenerational effects. And so I'm also sort of thinking that if we have this pattern by geography, state by state, that we may not understand the full impact of what these laws are going to be, because anytime we talk about reproduction, we're going to have to see this for generations to come. So we can look historically. One of my I apologize. I don't know who to credit this to, but one of my favorite sayings that I've learned is that, you know, history doesn't repeat itself, but it rhymes. And so we can look back to see, you know, what happens when we do these types of sort of large, sweeping legal restrictions, particularly on reproductive health care, is that it's going to have implications based on where you live, and then also based on your race, gender, class, and sort of other identities. And, you know, I also think that we are going to have to wait and see what things look like, you know, not just in our generation, but the next.
Thank you.
Yeah.
So Becky, you've got a lot of questions I see, so.
I do indeed. Okay, so first up, sorry, you caught me there. So lots of questions related to what we're seeing in Michigan. So Michigan citizens have collected signatures. They're attempting to get additional protections under the Michigan State Constitution. Do you see similar action happening here in Ohio? If not, do you think that'll be coming?
Yeah, I can take that. I think there's absolute appetite and interest to do some sort of ballot effort. It certainly won't be happening this year. If it were to happen, it would take place next year. It'd have to be on the November ballot if it were to take place. Of course, running any sort of ballot, anything in the state of Ohio is quite challenging. You have to get half the counties' valid signatures from half the counties. It's also extremely expensive, but there's been a lot of polling, and we know that the majority of Ohio voters support some form of abortion access in the state. So it's definitely on the table, and there's lots of interest, especially seeing what's going on in Michigan, that it may be coming. But that's all we have right now. I think it's absolutely something that, as we continue moving through these conversations and talking to voters, again, we're in a midterm election right now to see how that informs moving forward, that it certainly may be something that Ohio brings. So.
Jesse, question for you. What, if any, impact do you think that these the Ohio abortion laws have with existing laws regarding minors who are seeking judicial bypass in the instance of juvenile courts where they're seeking permission for abortion, where they do not wish to seek parental permission?
And Jesse, if you can explain that also a little bit too, so.
I'd be happy to, and I'm glad somebody asked that question because actually it was something I had meant to mention and didn't work into my remarks. But so if you are under 18 in Ohio and you need an abortion, but you have to either get the consent of one parent, or if you can't or unable or do not want to get parental consent, you can go to the juvenile court. It has to be either in the county where you live or an adjoining county to your home county, and ask the court to give you an order. The court has to decide whether you are either mature and well-informed enough to make the decision on your own, or that the abortion would be in your best interest. And then the court can grant you basically an order allowing you to consent without a parent to your own abortion. As you can, you do get a lawyer appointed. So, but as you can probably guess, this is an incredibly difficult process for any young person to navigate. Even an adult person might struggle to navigate a process like that. And so it was already a really difficult state of affairs. That has been the case in Ohio for a long time, for decades. That is still the law right now, but now notice that you have only 4 weeks after you conceive in which to complete this process and get your abortion. So, I don't know what the impact on the ground has been. Some folks who have been working with folks probably can say more specifically, but I can say that in general, young people discover their pregnancies much later than older people because they tend to have less regular periods. They are younger and have things going on in their lives, and then they have difficulty accessing all of these things, right? The judicial system, I mean, imagine how daunting that is, and as well as healthcare on your own, and of course the need for financial means, as well as all the logistical barriers. So although the law has not changed for those people under 18, it is so much more burdensome for them even than for adults to try to access abortion under these circumstances.
Thank you.
Another question, we read quite a bit and have heard quite a bit about the 10-year-old Ohio girl who had to leave Ohio to get an abortion after she was raped. Attorney General Yost declared that she would not have had to go outside to get an abortion because the abortion exceptions would have applied in this instance. Do you agree with that assessment?
Is that for me too?
Yeah. Sorry.
So yeah, I cannot tell you how many like fact-checking conversations I've had about this one. I mean, I do not know where Dave Yost is getting that idea. I confess I do not understand it. I mean, and again, I'm not a doctor, so I can't say, but about the medical side of it, obviously, my understanding is it's risky for 10-year-olds to carry a pregnancy to term. But, does being a 10-year-old constitute a medical condition that risks, substantial and irreversible impairment of a major bodily function? I mean, and if you're facing felony charges, if you say that it does and you're wrong, are you going to proceed under those circumstances? I mean, there's clearly no rape or incest exception. There's no mental health exception in the Ohio law. And, my understanding is 10-year-olds do give birth, and it's possible. I don't want to say never, and I don't want to say, because I don't have the medical judgment. And I also, if there were some other medical condition, sure. But I do not understand where Dave Yost got the categorical idea that this abortion would have been permitted. I just don't understand where it came from.
May I add something to that? I was listening to NPR on my way up here, and they were talking about this exact situation on the Reporter Roundtable, and they made an interesting point around this notion that it is not, that it could have happened in Ohio, what have you, and the politicization of the moment that we're in. We cannot forget that we're in the middle of a midterm election and that these folks are running for office. And that when you put things out into the media, folks who may not be in educational sessions like this, that may not have access, but are reading and consuming different kinds of news sources, that they're seeing this misinformation, and it has an impact. So I don't want to undermine the impact that top elected officials who wield immense power and have quite influence running for re-election, that there is another impact to kind of undermining and making what is to credentialed, well-studied attorneys and doctors who are doing this every single day not true, not evident, that we have somebody that is espousing otherwise.
Another question, we see that in the news, Florida is facing a challenge of their abortion law by a Jewish woman who is claiming that abortion law violates religious freedom rights. Do you see same or similar arguments coming forward in Ohio and likelihood of success?
Yes, and I do think I do see those arguments likely to be made. I think that there are, without going into a really long discussion of sort of religious freedom law and so on, I do think that there are really valid arguments here about that. I think that the challenge is that most of them are, because the stronger arguments under the law are the free exercise of religion arguments, I think, that say, this ban is violating my freedom, religious freedom, because my religion either requires me to provide abortions in this circumstance, or it requires me to have an abortion in this circumstance. But I think the difficulty, but I think that those are not going to be sort of magic pills to deal with this problem, because if you win a claim that your religion is being violated by a law, the remedy is that you get an exception to the law. So people who can claim that they need an abortion in this circumstance, or that they need to provide abortions in certain circumstances, will get those exceptions, but it's not going to make the ban go away. So, I do think that there are arguments, and I think they're important arguments, and I think they're arguments that are important to make, because it's important to remember that not all religious people have the same views here, that religion doesn't line up on necessarily on the anti-abortion side, not all religions, but I don't think that they're going to really be the legal answer.
Jesse, I think this is also for you. It questions licensure. Do you think that doctors, lawyers, and other professionals who receive professional licenses could potentially face loss of their licenses, either for having an abortion in a different state where it is legal, or assisting others in that act?
Yeah, I was going to say, I think that's the next panel. I'm going to defer on that one.
Fair enough. Fair
Thanks.
enough. I figured it was coming up, but thought I'd ask it in case you had something you wanted to contribute.
That's okay. Thanks.
So while Becky's looking, let me just ask all of you, and Colette, I'm going to start with you. And as we wrap up here in the last couple of minutes, this is just a very open question. What is it that, if there's one thing that you wanted to say here, or if you left and you didn't say it, you'd say, no, I wish I did. To the audience that's here and those who are watching from homes and offices, what would that point be? And that's going to go right down the line, so.
That's a big question, but I think that today, as I was, thinking about this panel and sort of the larger questions that are even just coming to me, just that I think that I would like to say that, all of us sitting in this room, a lot of you are lawyers, I'm not a lawyer, that we should really challenge ourselves to look at how we can grasp this problem at the root. That's what it means to be a radical person. I think that these laws are radicalizing us, even if we don't see it as such, and that we are really trying to understand why we are here and grasp that problem at the root of the cause. Why are we criminalizing abortion right now? Why are people not having access to this procedure that we see as necessary to a full range of health care? Why are people not able to exercise their autonomous decision-making around their reproductive rights, right? So I think that, sitting here wondering, what does it mean to be a physician? What does it mean to be a lawyer? What does it mean to be an advocate in this time right now? And how can we really grasp this problem at the root, because we have really not done that yet. So that's sort of a challenge even for myself, but just as people who do have an understanding of the law, people who do have an understanding of how healthcare systems work, how the law and the healthcare system kind of come together, right, in an intersectional way, to challenge ourselves to think more critically and potentially a little bit more radically, which I know that can scare some people, but really just this idea of thinking in that deeper sense of what we can do to change what's happening, and to make sure that we protect our communities when it comes to allowing people to make decisions about their bodies.
Thanks, Colette. Sarah?
Yeah, I think Colette summed it up pretty well. I guess the only few things I'll add here is that if it's not for abortion access, it'll be pregnancy outcomes, it'll be interracial marriage, it'll be same-sex marriage, it'll be birth control. The criminalization is quite sweeping, and if it's not something, if abortion access isn't what gets you up every day, like so many of us in this room, I hope that it compels you to, and if it's not, that you find another intersecting, connected issue that does, because I don't think any of it's off the table. And then the last thing I'll add to that is, understanding at the state level the lack of opportunity for any sort of protective efforts is quite narrow, and that we have to get really local, really interested in understanding limitations of authorities of, prosecutors in different counties, having our allies on different city councils across the state. Like, we really have to build a robust local network of allies who are interested in joining us in this work, because due to gerrymandering and a supermajority that is, advancing the very thing that we're talking about, we have to get local, and that's really where meaningful, tangible change, especially with regards to these issues, can be made. I mean, we saw City Council give over $1 million to the Abortion Fund and the Ohio Women's Alliance and Pro-Choice Ohio to do mutual aid and practical care support work that will make a meaningful difference for those residents. So if you are somebody that's connected, to folks that have that kind of power in your city and your county, please get a hold of them and get connected with these organizations, so we can help add capacity to have those conversations and move those policies.
Josie?
Well, I guess from my legal perspective, where I would go is that, I think there's a real irony in the decision in Dobbs. There was this view that this was going to be settling the problem once and for all, right? Give it back to the states, and now everything, overrule Roe, and all the problems Roe created go away. And I think we're really seeing all the problems that the Dobbs decision is created, there's been absolute chaos across the country on the legal front. And really, I think these laws were never written with the expectation that they were going to be put into effect. And I don't think they were written to be put into effect. And I think there's a real danger when we have non-physicians writing rules for physicians. I mean, we don't have legislators telling ENT docs when they can, put tubes in someone's ears, and we don't have them telling general surgeons when they can, remove someone's liver or something, right? Like they don't think that they know that medicine, but they're writing rules for physicians here, and they're writing them, backing them up with criminal penalties. And I think that that's a really bad thing, and that really patients are going to be paying the price, and we're going to be seeing that more and more going forward. So.
Very good. Colette, Sarah, Jesse, thank you very much for joining us today. All right, so ladies and gentlemen, as we go into our final session today, just having finished legal challenges and future legislative actions, our next panel is going to take a closer look at the variety of regulatory limitations and prescriptions for healthcare providers. I do want to just make a few comments about today's forum and the CMBA. And for those of you who are also joining us online, this is being hosted today here in the auditorium of the Cleveland Metropolitan Bar Association. You can come on up, guys. We just set up, yeah. The CMBA's mission begins really with 5 simple words, and that is to promote the rule of law, to promote the rule of law. To believe in the rule of law is to believe that all people and all institutions are subject to and accountable to the laws of our land. It also means that we believe all laws must be both fairly applied and fairly enforced. While today's conversation is centered on reproductive rights, throughout the year, this organization, the CMBA, brings together experts representing a variety of perspectives, political persuasions, and viewpoints to deconstruct some of our most complicated legal issues. At a time when our state and our country is so deeply divided on so many subjects, the need for fact-based civil dialogue has never been more important. And so I invite all of you to continue to participate in today's discussion, but also to return again for the future conversations that we have here at the Bar Association. All of the future programming is on the website. I would also like to just make some points. As you've now seen in our 4 sessions, session 1 being medical, social, and so forth, 2 legal, 3 more back to the procedural medical, and now 4 here we are with going back into legal. What you'll see from panel 4 is, and there was kind of reference before, you've heard from criminal lawyers, but this area of law is in need of guidance by so many other types of lawyers, as we'll hear today from Susan Scheitzel and from Vicki Vance. They're going to talk to you about the other implications that come up in this. And so it's important, the education. And that's really what today is about. Not necessarily to take positions, but to educate on what the landscape is. And so with that, I've already kind of introduced, but the very far side is Vicki Vance. To her right is Susan Scheitzel, and to my immediate left is Dr. David Burkons. And so I'll start with you, Vicki. Actually, let me get my outline here. Thank you. So, excuse me, give me 1 second. I've got so many papers up on this thing. Thank you. Thanks. Thank you. All right. All right, so let's begin. Actually, I'll start with you, Susan. I apologize. I'd like to start with kind of the overview of the Ohio laws and rules that are now in effect, or that will be starting to be.
Okay, thank you. I'm going to make an introductory comment before I start, and that is that I can't see everybody on Zoom. I can see the people who are here, and it is so wonderful to see so many young faces. I'm old. I was a sophomore in college with Roe versus Wade, and when Roe versus Wade was decided, and I had seen my freshman year many of my friends go to New York and go to Mexico and live under this kind of a structure. of every state having different abortion laws. 43 years ago, Planned Parenthood hired me to be a lobbyist at the State House, mostly on abortion issues while I worked my way through law school, and I will be forever indebted to Planned Parenthood. And I want to tell all of you young faces, you will never be out of this issue. It will be with you for a lifetime. And here we are. So we're kind of acting a little bit cleanup here because a lot of the things that we're going to talk about had already been discussed, and I had wanted to talk about juvenile informed consent, so I appreciate Jesse picking that up. But to recap, I mean, we have had some, I would say, reasonably strict abortion laws in Ohio prior to what I call the second heartbeat bill. The first heartbeat bill, which Jesse and I were both involved in fighting, was the one that basically said that the clinic needed to see if a heartbeat could be detected, and if it could, it needed to tell the woman about it and let her hear it if she wanted to hear it. We thought that was pretty onerous. And then the second bill came out saying basically that abortions cannot be provided after heartbeat. So that's where we are. I mean, we call it this, as was pointed out, we call it the 6-week ban, but it's really after the heartbeat. Ohio has something that may be particular to Ohio, and that is that medication abortions have to be given by a physician. So it is not a situation of somebody being able to get a prescription and going to the drugstore and getting it. And there's some real regulations about the 24-hour waiting period and all of that. So a question that comes up to me often is, there was a time, I guess, that abortions started being done in clinics and by abortion providers and generally are not done in a physician's office. There's nothing that would prohibit an OB from providing the medication abortion if that OB wanted to follow all of the regulations. And so we may or may not see some OBs, probably those who are independent, because not necessarily from the big healthcare institutions, who might want to sort of get into that. So it raises some interesting issues in terms of somebody who may get a prescription from an out-of-state abortion provider. Will they be able to get it filled here? The Biden administration recently sent out guidance to all pharmacies, basically saying you can't refuse to fill these prescriptions, although if it's against Ohio law, I don't know what would happen there. We're still trying to sort a lot of this out. Some things that are old, it was mentioned that an ectopic pregnancy is considered an abortion in Ohio, so it's always had to be done by a physician. That's still around, although the heartbeat bill does not apply to ectopic pregnancies, although the reporting, I believe, will. We've always had abortion reporting so that there's abortion providers need to report to the state of Ohio. That's to say it's considered the same as dog bites, burns, all kinds of reporting. That becomes important because I'm going to come back and talk to that regarding HIPAA. Abortion is considered the practice of medicine, and so the law specifically states that. So that is something I think, even though criminal penalties may not be going on right now for people who drive somebody to an abortion clinic or whatever, if somebody is actively assisting somebody with a medication abortion, such as drugs that they receive from out of state, that person could be prosecuted for practicing medicine without a license because it is considered the practice of medicine. So that's all still here, and then the juvenile informed consent. If any of you, I do not know actually how young women get to the courts. I know I have talked to some of the court-appointed lawyers for the young women and how they go about what they do, but that's an area that probably needs volunteers just to get these kids to the courts and and help them out, or it may essentially with the heartbeat bill be something that is impossible to be done. Okay, so that's where we were. Then the heartbeat bill starts that you cannot have an abortion after a heartbeat is detected. So, and those have all been covered. So what do we have? And any good news in this? And I think that there is. One of the things I want to talk about is EMTALA. And EMTALA is called the Emergency Medical Treatment and Active Labor Act. And what EMTALA says, and it's a federal law, and it will preempt state law, meaning it will take precedence, no, the state can't change it, is that anyone presenting at an emergency department in a medical emergency or in active labor must be treated by that emergency department. They cannot turn them away. Now, they can charge them later. That doesn't have anything to do with payment, but the hospital does need to care for women. So if we do begin to see women who are having medical abortions or self-induced abortions who run into medical problems, they should go to the hospital. The hospital has to take care of them. The reporting law that exists currently is, and I say all of this is what exists currently, because of course you saw the litany of bills that may come down the pike. But the reporting law is upon the provider who performs the abortion. It isn't on anybody else. So if a woman presents to an emergency department with bleeding or complications or something from an abortion, the hospital needs to treat that woman, and there is not going to be a report on that, or there should not be a report on that to the state. They did not provide the abortion. They don't need to report the abortion. I should have mentioned that for the past 40 years, I've represented hospitals and doctors. And so certainly that would be the advice I would give clients, is that you don't report if you're just treating a complication of an abortion. It may get a little complicated if, in fact, the abortion is incomplete and the hospital does some treatment that continues that. But that's really way beyond what we're talking about. Today. So women should not, at this point, should not be discouraged from going to the hospital if they have needs after an abortion. And they should not necessarily be discouraged about telling the truth about what's going on so that they can get adequate care. And there's nothing that the state can do that will change that. I mean, the state can't pass a law that says no hospital can treat somebody after they've had an abortion. They will not be able to. The second federal law that also preempts state law is HIPAA. And HIPAA, as you probably know, the Health Insurance Portability and Affordability Act, creates very specific guidelines for when patient information can be given to anyone. It does permit a hospital or a provider to report when there is a state law requiring reporting. So that would include abortion reporting, that would include dog bites, burns, that kind of thing. But it has to be a state law regarding uniform reporting. It can't be the Department of Health coming in or a prosecutor coming in and saying, hey, I want the information about this woman. There's some very narrow exceptions under HIPAA for giving information to law enforcement, but it has to be when there is an imminent risk to public health or the safety of another. And a woman coming into a hospital after she's had an abortion is not creating an imminent risk to the public. And I would say that information cannot be given to the police without either a warrant or a court order. So there's a whole process that has to go through. And while the state can pass more restrictive laws than HIPAA regarding patient privacy, it cannot pass and enforce less restrictive laws. So we do have those two federal laws that will provide some confidentiality for women who need and seek medical care at this point, either from a hospital or from their doctor. And so, women should be encouraged to be honest about what's going on so they can receive the appropriate treatment. That's sort of my
Thanks,
wrap
Susan.
up. And
Thank you, Susan. And Vicki, before you start, I'm going to go a little bit out of order here, if you don't mind. And I'm going to ask Dr. Burkons a question. I think this is a good time for it. Dr. Burkons, you being a provider in the state of Ohio, I'd ask you to kind of share with us what your concerns are as an Ohio provider for your colleagues, for patients, and the overall practice of reproductive medicine in Ohio.
Probably have two parts to that. One is under the current law, and one that is assuming that the legal strategies that Jesse talked about don't go into effect. We can almost be for sure that sometime later this year or early next year, abortion will essentially be outlawed in Ohio altogether. There's no doubt about that. So our questions are, one, under the current law, do we have any liability, either legal or professional, to the regulatory agencies, if we provide referrals to clinics outside the state, if we actively not just say you can go there, but actually maybe have contact with those clinics? And secondly, can we actually do some of the pre-abortion work that's often done, lab work, ultrasound, that sort of stuff, and then provide that to the clinicians in another state as long as the abortion is completely completed there? That's one of the questions we have. Secondly would be if...
Doc, I'm going to stop you right there. Susan, because I see you kind of saying you'll answer that, so.
I see no restriction at this point on counseling and referring regarding abortion. Okay, the law applies to the physician who performs the abortion. So counseling, making a referral, I think OBs are probably going to be inundated very early for pregnancy tests, although I know that over-the-counters are very effective. I don't see any problem for that. You raise an interesting issue about whether or not you are providing the lab work here, which can be sent. I'd like to think about that. I don't know, do you have my inclination is that wouldn't be a problem, but I don't know. I'll think about it.
I don't, on behalf of the physicians in the practice of medicine, I would not expect that it would be impermissible to do some preparatory lab work before sending a patient off for a procedure. We see that done in lots of healthcare settings and situations where a resident may be planning to have a surgery in a different state, planning to vacation in Florida, and therefore we're going to do the prep work up in Ohio. So from a practice of medicine, medical information can transmit from organization to organization and be effective and well received on the receiving end. What I would worry about hearing from the second panel are those rules around aiding and abetting, and whether there would be any interpretation given to those rules, those criminal rules that would say that a doctor in Ohio, let's say, is doing something to aid and abet a crime or a criminal action, particularly if that individual is now going into a jurisdiction where it is, there may be other, again, criminal implications or criminal potential. So taking an Ohio resident, doing the prep work so they can go to a safe haven of Michigan, Michigan may not have a problem with it. I don't know if anyone in Ohio would, and because you're dealing with an Ohio, presumably an Ohio patient, an Ohio resident, who then is going to come back to Ohio. Don't know how that will be interpreted. It seems to me that's going to be more of the strength in the view of the criminal prosecution system. I don't see from a medical practice that there's any difficulty with sharing and collaborating on medical prep work for a procedure generally, but in this case, we don't know.
Not to get too overly legalistic and speculative, but I would imagine that might be interstate commerce, and the feds could regulate that and allow it to be okay, but I don't know
So if
that.
you can just explain, because a lot of our viewers are not lawyers, just interstate commerce even.
Oh, okay. I don't know if I can explain this in a couple in a couple words. The Constitution gives the federal government very specific powers, where the states have broad powers. And a lot of those powers are to wage war, to run the post offices, those kinds of things. But it also gives the federal government the ability to regulate interstate commerce. And so it is likely that, for instance, if Ohio wanted to pass a law that said someone could not go to another state to have an abortion, that could be struck down because if there was a federal law, and in fact, that the federal law has been brought up and passed in the House and struck down, and one of the things that did was to say that the states can't pass abortion laws which would affect interstate commerce. And so a real quick explanation of interstate commerce is, the states have the power to regulate health, safety, and welfare, so all the mask rules and all of that stuff for COVID came through the states. However, the states couldn't regulate people crossing state lines because that's interstate commerce. So I suspect, and of course, all of this is based on a favorable Congress that would pass certain laws, but I would suspect that the feds could come in and they regulate interstate commerce and could stop the state legislators from impacting that.
Thank you both. Dr. Burkons, you had said the first of two concerns, your other being?
The other being two things, that if some of us are considering possibly getting licensed in other states, mainly at this point, depending on how the elections turn out, Pennsylvania and Michigan, and referring patients, actually opening clinics in those areas. If indeed we do that and we're licensed in both states, and one of our patients goes to a clinic in Pennsylvania, the abortion is completed completely there, they come back here, are we going to be under any, because we did something that we were legally allowed to do under our Pennsylvania license, which we couldn't do legally here for our Ohio license, is that going to have any effect potentially on us at either the ODH or the state medical board?
Well, my take on that would be that if you have a physician who has a license in Pennsylvania and a license in Ohio, and what they are doing is going to Pennsylvania, practicing under the jurisdiction of the Pennsylvania Board of Medicine, or its equivalent, pursuant to their Pennsylvania license, and everything they're doing in Pennsylvania with that license for those individuals there is considered proper and permitted by Pennsylvania regulatory authority, I have a hard time imagining that that individual doctor can now return to Ohio and be met at the border by the Ohio State Medical Board saying, shame on you, what you did in Pennsylvania, you would not be allowed to do in Ohio. I'm having a hard time seeing how they would be able to try to exert that jurisdiction across state lines, provided that everything about that patient encounter was indeed in a different jurisdiction, and that patient doesn't come back and give any sort of an anchor or a hook, I think, to the medical board. I wouldn't believe so, but again, that would be a quick sense of the scope of the authority of the state medical board.
Perfect, thank you. And Vicki, I guess that's a perfect way to get to the next questions, which are the evolving legal landscape now raises obviously substantial risk and compliance concerns for Ohio medical providers. So if you can discuss that with our audience, please, kind of what those risks are.
Thank you. After looking at the whole available law and the rules that are coming, and as we've heard from our prior panelists in today's sessions, the law is changing rapid fire. And there is so much happening. There are so many concerns that individuals have about what they did yesterday is no longer going to be proper. What can they do tomorrow? Is that going to be available? Is the profession that they love so much, medicine, now being criminalized, and what's going to happen to their future careers and desires to practice? I saw anecdotally that at a medical school, not far from Ohio, I believe, if I read this correctly, a near entire audience of about to be medical students, the white coat ceremony that they dream of, getting that white coat to say congratulations, they walked out of the auditorium because the speaker was speaking on a topic dealing with pro-life that many people in the audience found unacceptable. So that's it is very evolving and very changing. What I was asked to kind of take a look at is, so how do you navigate through this kind of a challenging world, and what are the compliance considerations? Again, realizing that we have to tread carefully. We as lawyers like to follow the law, doctors like to follow the law, so we're trying to follow the law together in some of these topics, while also recognizing that there is just, again, some answers to questions we don't know. So I put together the slide that you see over my shoulder that just tries to show at a glance that this is so many different angles of consideration are affecting both providers and patients. And as you look through here, I was trying to just highlight all of the various offices and jurisdictions and stakeholders that are going to be speaking and trying to address this issue. And so just kind of going around the horn here, you see starting at the top, I identified the medical boards and other relevant licensing boards in all the different states. I'll link this together in a moment, bear with me. So as you move clockwise, you're going to get to the ODH. We've talked about them a lot. They are an important state organization. They are charged with a wide swath of responsibility to keep our families and our individuals safe, and their public safety is paramount. We have them to thank for helping steer us through greatly the COVID experience. So hats off to ODH, but they do have a job to do as well, which we have to navigate. You're going to get to the burden that is coming through this system with all of what we're now seeing is not only the prior, but now seemingly amped up forms, reporting, documents that have to be filed, that have to be maintained in medical records and sent into the ODH. You've got patient consent issues. There have been versions of them in the past. Are they going to be looking and reading with a lot more complexity now? The State Pharmacy Board, we're keeping an eye on them, but so far it seems that they are evading or avoiding, or at least not being in the crosshairs initially of some of the reporting obligations, and because of so much of the medications that we've talked about don't pass through their doors anyway. But they're watching, I know that they are, to see what's going to happen next. We had a great panel earlier about the criminal exposures. Wrongful death claims, I do want to come back to that because I'm fascinated by that in particular, and then all the civil exposures. So what is this telling us? Well, let's sort of try to pull some of the threads together a little bit. You start looking at the medical board and all of the rules that they obviously are charged with following and issuing and enforcing. But now through these different pieces of legislation, we're seeing the Ohio legislature turn around and tell the state medical board, you must do certain things. You must take discipline. You shall discipline. You shall find ways to look to the providers, the physicians, even in particular, and mete out discipline if they do not follow the rules and the laws with regard to medical record forms, with regard to conversations with their patients, with regard to filling out the forms and submitting them in to the state medical board. That tone of telling the medical board what it shall and shall not do, I know that they are very important, but they too are a jurisdictional body. They do have individuals there that exercise something akin to a prosecutorial discretion. I have been and worked with the medical board many times in order to help talk to them and reason with them about the enforcement authority that they have. So it's worrisome that the state medical board is now being told rather emphatically certain things that they must do. You look at the state, I've looked ahead at the state nursing board. We have advanced practice registered nurses in Ohio. So far, the nursing board, I think, again, may be a little bit not being touched yet by some of these issues, but we know that they will in some form or fashion, I suspect. Doctors' offices and clinics utilize nurses. LPNs, registered nurses, advanced practice registered nurses, some with and without prescriptive authority. Yes, abortion is a medical procedure, but we also know that the landscape for the APRNs continues to evolve and expand. So we wonder and watch for how will this affect what they do and how they serve their patient, their clientele, and also the physicians with whom they have collaborative agreements. I look then at the mandatory forms. Again, the state medical board or the ODH and the legislation is telling the doctors fill out these forms. These are forms that very much involve, moving down the horn a little bit, patient-informed consent. You know, what had been a very private, almost sacred relationship between patients and physicians is now being invaded, if you will, by not only individuals wanting to know exactly what the doctors and patients say, but the manner in which they say it, the materials that they hand off. Again, we've seen it in the past, we're seeing it even more now. And then we have the laws saying, and doctor, if you don't give that informed consent, if you don't get that information in writing, if you don't have the patient signing an acknowledgement form, if the notation is not made in the medical record just so, you are subject to discipline. Again, it's the sense of an invasion, if you will, of the most profound relationship that we often think about is the patient and physician relationships, and now how that is being not only criminalized, maybe not for the patient herself, but also for her physician. It is very worrisome. Introduce into that world of medical records, what we are living with now in today's world are electronic medical records. And with electronic medical records, I know and from the litigation landscape that comes requests for what are called audit trails. And so there will be requests, I imagine, as if there is litigation around these topics of what does the electronic medical record show about what was entered, when it was entered, was it entered timely in the medical record, and who entered it. So there's an audience out there called the audit trail and the IT folks who can be looking at electronic medical records if those are utilized in these settings where abortions are being performed and this type of counseling is being rendered. Think also about some of the laws that we have that say these forms that contain an immense amount of very personal detail about the patient must be stored in their medical record for certain periods of time. But the laws are sometimes saying that those are confidential, but they have to be in the medical record, but they're not public record. So think about the burden you're now putting on medical records departments at these institutions who are trying to deal with electronic record, even if it's electronically stored or paper stored, and sorting out what can I hand out, what can I distribute, what if I get an authorization to release records from something benign about a woman, let's say an auto accident, and somebody wants her records because she came in and they need all of her records for an auto accident. What if in that body of records are the forms, the reporting forms for an abortion that are supposed to be in her record but are not supposed to be public? How do you pull those out? How do you make sure that those are going to be protected? Again, compliance issues at a very operational level at some of these facilities. But then going up on the left-hand side of the clock here, I wanted to come back to the wrongful death claims, which is part of civil exposure, not so much criminal, but civil. So many of the bills, some passed, some that were passed, but pending or enjoined for a time. Some of those have now been, the injunctions have been lifted. Some are still in the pending stage because there's a lot of hot litigation around them. But I look at those and, again, having done medical litigation, you're seeing basically the bills telling individuals, women, you have the right or you shall bring a civil action, bring a wrongful death action. And when you bring your wrongful death action, it should be for certain types of relief that you are allowed to sue for, and your damages will be compensatory damages, punitive, what they sometimes call exemplary, but that's code for punitive damages, and you will get attorney's fees, and you will get court costs. And you have a time frame in order to do this, or sometimes they don't specify the time frame. Well, let me just pause on that for a second. These are wrongful death claims being told to be brought by the woman, and if she's a minor, it could be brought by her parent, so the grandparent, putative grandparent, I suppose. They are suing for wrongful death And usually in the wrongful death jurisprudence that we have in Ohio, viable fetuses can be the subject of a wrongful death case, viable. And there's good law on that here in the 8th District Court of Appeals in particular. So a viable fetus, let's say suffered a loss in a car accident through a wrongful car accident, a fetus can be the subject of wrongful death. But a non-viable, we know from the IVF litigation, a non-viable unimplanted embryo is not a subject or a person for wrongful death. That was decided in the IVF litigation a couple of years ago. So now we're sort of in between those two. It's implanted, but it's an embryo, but it's not viable. So is that entity a human being subject to being a person in order to be subject to the wrongful death statutes? Now, there is a pending bill that I think is going to try to change that. But imagine right now what our situation is. We're going to be inviting women to bring a wrongful death action on behalf of a non-viable 6-week or 4-week fetus with a heartbeat. But we're telling these individuals that they can bring both compensatory and punitive damages, which is going to be, I think, subject to some challenge because the standards of proving that are different in the civil world. Punitive damages are usually bifurcated and set separately, and all of this is the province of the jury to award damages. And yet we're now saying that you have a minimum $10,000 recovery and then some. Plus, you're getting the opportunity for attorney fees, even if you don't have punitive damages. And again, that notion of winner-loser pays attorney fees is something that, in general, in Ohio, subject to certain state statutes, is usually not something that we recognize. So I look at all that we see here, and you're thinking of the myriad of challenges that await all of us practicing in this area, whether you're counseling women, individual women, potential plaintiffs, physicians, their facilities, their hospitals, their clinics. The intersection of all of this is fascinating. Like Susan, I've done healthcare law and healthcare work for my entire career. I've always been drawn to the profound nature of what we are addressing when we deal with medicine, and to see and to experience that which I know Susan and I have seen in a hospital setting, and to see it being challenged and really put under tremendous strain under the current regime is something that is really it's tough to watch, and we want to see what we can do to get to the right result. We as lawyers follow the law, and we want to do it smartly and thoughtfully to the best of our ability.
Thanks, Vicki. So I'm going to move on and come back to you, Susan, and really talk about the operation, the abortion mandates now in effect. They may take considerable time. Help us kind of understand what those issues are.
Yeah. Well, I think we'll see in Ohio, at least for some time, abortions continuing to be done in abortion clinics. I mean, you may find a few physicians out there who decide to provide medical abortions in their offices. In fact, I call them surgical abortions, but the first panel said procedural abortions. Right now in Ohio, to do a procedural abortion, the facility has to be licensed as an ambulatory surgery center, which is considerable licensing requirements. So I really don't see procedural abortions moving out of the abortion clinics. Whether or not there are individual physicians who decide to do medical abortions in their offices remains to be seen. They may, and they will need to seek legal counsel in terms of the myriad of regulations that Dr. Burkhans has been living under for a long time. And certainly the abortion clinics will need to look at all the questions that you're looking at. In terms of other providers, I think, I mean, if my practice is any indication, other providers who are counseling, OBs who are counseling, hospitals who are going to be as they always have, taken care of post-abortion complications, are now looking for guidance. There's a tremendous amount of misinformation out there. I shouldn't say it's misinformation. The fact is that we now have 50 different states with 50 different laws, and the national media is covering some of the high points of various laws, and then people think that it applies here. So women think that they can't get an abortion here. I've had people say to me, that abortions are banned in Ohio, which they are not up to the heartbeat. So it's going to take some time, and unfortunately, as a healthcare lawyer, it's going to be changing almost every day. So I can give advice right now and say I think that a physician can certainly counsel on abortion. I can say I think a physician needs to counsel regarding abortion. Vicki mentioned informed consent. And informed consent is really required for every single medical procedure. And it means the physician, before they do a medical procedure, needs to inform the woman or the patient of all the risks and benefits of having the procedure and the risks and benefits of every alternative, including doing nothing. So I would contend that if someone goes into an OB's office and they have an unwanted pregnancy, the physician must give the information, the full information about what all the alternatives are. Real informed consent really has nothing to do with what the state has said in terms of this information that has to be given out to women when they come into an abortion provider. And I've always contended that the abortion provider needs to, I guess, follow the law and give the information that the state requires, but then really give the real information. What are the risks and benefits? What are the risks and benefits of pregnancy? This definition of substantial and irreversible impairment of a major bodily function, any medically diagnosed condition that complicates the pregnancy. I was looking at that in terms of the discussion of age. I don't know that young age or old age is a medically diagnosed condition, but probably is. Providers and hospitals are going to have to start working this out. The reporting, there are, and I don't know, because I'm not there on the ground, I don't know how often, but there are abortions that occur because a late stage abortion because of, a woman develops cancer and needs to have an abortion so that she can have the cancer treatment, or there's some kind of medical condition. And certainly, even in facilities that don't generally provide general abortion services, they do abortions in those cases, and they're going to be needing to work all of this out, and it's going to take some time, and it's going to be changing. You may have something to add. I think
that's
Perfect. Well, thank you. But we've got a few questions here that Becky, I know, wants to put to the panel.
First question is, President Biden signed an executive order on July 8 directing federal agencies to take steps within their power to safeguard abortions and reproductive health services with a variety of provisions. The question is what, if any, effect does that executive order have in Ohio?
Well, I think what's happened so far, and Vicki may be able to respond to that too, is there have been a number of directives that have come out from the federal government. There's been a directive to all healthcare providers regarding HIPAA that basically says, you cannot you have a police officer show up at the door and you want to know if a patient has had an abortion, you can't give that information. So that certainly has been helpful, and all our providers have been reminded of that. There's been a similar directive regarding EMTALA, telling all hospitals that they must treat complications from abortions. They cannot refuse to treat those. I'm not sure. I think there may be some things regarding like VA hospitals and those kinds of things of which I'm not aware. Do you know anything else, Vicki?
No, the only other thing that comes to mind is when President Biden was telling his administration and the agencies to try to provide some, again, counseling and/or information on this. One of the other HIPAA-related announcements that came out, again, from Health and Human Services and their Office of Civil Rights, which is the branch or the division within HHS that supervises and enforces HIPAA. They also went so far as to offer sort of a public service announcement to folks about how they can manage their cell phones in order to turn off locating information or to be really thoughtful about what apps that they use to track their periods or to indicate where they might be going, telling them in so many words from OCR that here are instructions how you, if you have an Android device or an Apple device, here's how you ought to think about turning off that information. Don't get your information via apps. Don't put this information on your phone. Turn off the locating services. And also reinforcing that if anyone has any concerns that their personal health information is being compromised, that they can always go to HHS, Office of Civil Rights, and file a complaint, and they gave instructions about that. I think the message that the government was trying to, as I understand it, trying to send out was to have an administration response to the Dobbs decision and to emphasize where there was federal relief available. And as Susan already mentioned, some of these are federal rules that will cut across all state lines and are being viewed, depending on the jurisdiction, may be viewed as mandatory federal laws that must have and will be given preemptive effect that will control in different jurisdictions.
There's also another law that neither Vicki or I speak for you are qualified to talk about, and that's ERISA, which is the Employment or Retirement Security Act. And that the health plans, if they're self-insured, and most big companies have self-insured health plans, they're governed by federal law. And so if the health plan covers abortion services, there's been some directives that they can't exclude that. You know, a lot of companies are dealing with whether or not they should be paying for travel to go to another state. But if anybody is covered by a health plan that covers abortion services and they abruptly discontinue it, that may be prohibited. And I'm not a health plan retirement lawyer, but that's another area that's out there.
Thank you. We've got many questions related to EMTALA, so I'm not sure how much of this we can do, but I'll hit a couple of them. Under EMTALA, it is if a woman presents herself, the hospital is in an emergency room. The hospital is required to treat her. If an abortion is necessary to save the mother's life, is the medical provider able to do so? And related question, if they do in fact present themselves at an emergency room and have abortion-related complications, is the emergency room physician and staff required to report that woman because the fetus was or is in danger?
Let me take the second one first, because it's the easier one. If a woman presents with abortion complications and the abortion has already occurred or is in process and is not going to be stopped, no, there's no reporting. The hospital emergency room physician is not the one who performed the abortion, and the reporting requirement is on that person under current law. Now, there are some very detailed rules about if the abortion is necessary to protect the health of the mother. If it is post-viability, it has to be done in a hospital with neonatal services and variety of things, so there would be a transport. But yes, if it's pre-viability and it's to save the health of the mother, I think the emergency room department, if it's an emergency, the hospital is required to treat that condition. Mm-hmm.
I would just add to that is consistent with directive that did come out on EMTALA that said specifically that when individuals come to the emergency room, and it has to be a hospital emergency department, not an outpatient office and not an urgent care, but a hospital emergency room. And if they need, there's a duty to examine those individuals, men, women, children, anyone who presents. They have to assess whether or not they're having a medical emergency by certain definitions, and they have to be rendered stabilizing treatment to help deal with that emergency to the best of that facility's capabilities, and then if need be, transfer them to a higher level of care if necessary. In the emergency room, they also have to be able to have a list of consultants available that they can call down. So if they need neurosurgical care or obstetrical care, hospitals are required to have some availability. If they don't have those individuals on their staff, then transfer them. But as part of that directive, again, that just came out earlier in July, I believe, that the government did say that if that stabilizing treatment in the physician's judgment to stabilize that medical condition is an abortion, then the abortion has to be performed, and that will preempt state law.
That would need to be reported under state law in that,
Yeah.
in that situation. If the emergency department actually performed the abortion, yes, that would need to be reported.
Please, Dr. Burgons wanted to add one thing.
Again, I'm speaking now not so much for what I do, but for what some of my colleagues will do who are going to be called to the emergency room when patients present. And I think one of the key things is I think that the hospital attorneys have to make, it can't be seat of your pants. I had a resident from one of the local hospitals at my clinic the other day. I said, what are the rules at your hospital? And basically it was what you said. If the patient is an extremist, treat them right away. If they're not, call the lawyers. And the lawyers need to have most of this stuff set up ahead of time so you know what to do. And I can give an example of what I see is there was a few months ago, there was a case out of Cincinnati in which a woman who was somewhere in her mid-20 weeks got a hold of misoprostol. And again, misoprostol, which is the second drug we talked about, is a very cheap drug. And with, a bottle of it, which is very cheap, you can abort an elephant. I mean, it's, it just works. And she, in a hotel room, passed her fetus, then went to the hospital, and some charges were filed against her. I don't know what they were. The question is, what if it's going to happen with a lot of women who are going to self-medicate? What if she had halfway through this procedure panicked and gone to the hospital, and now she was, 3 centimeters dilated, but still had a viable fetus, which normally people would start what we call tocolysis, which is stopping the labor. And what if she says, I don't want that done? And maybe it's a viable fetus, it's right at the edge where it's viable, not viable. And I mean, I think these are the things that emergency departments, and immediately they're going to call GYN. So that have to have something in writing or something that you can say in good faith, well, I can let you pass the fetus, or no, because this one may be more than 24 weeks or whatever. We have to, we have to go against your will and try to stop the labor. And I think that's what has to be done.
Yeah, you raised that question, that scenario when we talked in preparation, and I've been thinking about it ever since, because it puts the hospital, you essentially, if you do treatment that the patient doesn't consent to, you're battering the patient. So it forces, that would force the hospital to choose between battering the patient or following the state law. And I don't have that worked out. I can tell you, and this is, we should have probably been better prepared, but many of the health law organizations, American Health Lawyers and others, are trying to educate, although again, every state is different. So you're absolutely right. The hospitals are going to have to work this out and have policies in place so that when it comes up, they're not calling us at midnight saying, what do we do?
I mean, particularly if they do pass this personhood thing, which then says even a 16-week fetus is a person.
I know Ian's going to cut me off here because we are already past our time, but I'm going to ask one more. We did get several questions from people saying we've heard a lot about what the potential liability is for medical providers, doctors, nurses, but what about frontline staff, receptionists, medical records workers, anyone who touches records? Should they have concern for potential prosecution? And on the flip side, we had someone ask, is there anything stopping an employee who claims a conscientiousness or a religious concern from coming forward and voluntarily disclosing information about a woman who is contemplating seeking an abortion?
Go ahead. You could-
Well, again, I'll take the second question first. Certainly, it would be a HIPAA violation to disclose that. Now, that's not to say it can't happen, so, I mean, HIPAA protects, but only to the extent that people want to follow it. If that was done the person should be fired, all of that. Ohio has had a conscientious objector statute regarding abortion for as long as I can remember, so that people can refuse to participate. In fact, that's recently, in about the past 2 years, been extended to other things other than abortion. And so you've probably heard the news about if somebody doesn't want to participate in a transitioning surgery or something of that sort. So certainly, people do have the right, and it causes problems in hospitals sometimes if they're doing something in an emergency and somebody raises their hand and says, I don't want to do this. They've got to make a good faith effort to find somebody else. But that's been around for a long time. Regarding the liability of anybody who works with an abortion provider or with the hospital, Vicki, do you have anything to say about that?
Well, I think the language of a lot of these statutes and bills that we've been talking about here today are phrased in terms of primarily the provider or the person who does the procedure or who does the counseling, not the support staff and or the ancillary staff that work and help that happen. But the language of the statute, if read for its purpose, would be directed at the individuals who are performing it. So I think we've been given proper attention here today to those risks associated with those individuals. Some of the statutory language speaks about facilities and what the burden and the obligation on the facility is and how that might be defined, which might include hospitals or clinics or locations where these procedures are performed. I have not read anything that gets down to the granular level that any employee of these organizations bears personal liability, and I would again, analogize this to a lot of the medical litigation work that I've done over the years. Most individuals, if they are a license holder, if they're the nurse, if they're the doctor, if they're the PA, or they have a certification, with that license carries responsibility to accord yourself and comport yourself in accordance with your license. But if you're the individuals who work at the facility, the receptionists, the secretaries, the medical records staff, these are the folks that keep the engines running and they help the facility move forward. But I can't say that I have ever I think it's a rare situation where a nurse or a secretary or an assistant or a receptionist is going to be named as a party to a lawsuit. They have no license at risk. And most institutions that I'm familiar with look and realize that they exist because of the good work of their people that work there for them and will take on any responsibility or liability that might be directed at the organization as a whole. So I would suggest that those individuals have less at risk. Because I think what comes next is they worry, well, does that mean I have to go buy insurance? And you can just imagine how that list of questions goes. And I would say, I don't think so.
So before I say thank you and before we ask for applause, let me thank all of you for being here today. The legal and medical landscape of Ohio's reproductive rights. Today you've heard from patients, the counselors, those that help during a difficult time, providers, I would say the interpreters, the lawyers. And what we heard today, and I think is very clear, is that the landscape is changing in real time. And there is much change, and it's just coming fast. And so because of that, what I would suggest is, and I think we all are very clearly can take away the fact that education is key, and it must continue if we are to stay abreast of all of these needs in this area. And so I would suggest that continue, please, going to the forums, continue looking, as I had suggested earlier, to the Cleveland Metropolitan Bar Association. Today, bringing in all these people, we took a high-level view, but we know that it's going to be different tomorrow. We know we're going to need specific training. And so keep looking, because we will keep teaching it here. That's what we do. And The other place are the trained lawyers, those who are learning this, those who have been practicing in this area for many years. What we are doing, and those of you who are watching on video, you had heard reference earlier today to kind of a strike force or a rapid response team. And what that is, and you'll get more information here in the coming days, are lawyers across the state who are getting trained to respond to that case or cases that may come in any part of the state. And these are lawyers who are not only caliber lawyers in criminal defense, but also in this area. They are geographically diverse, they are trusted, and they are vetted. And those of you who are watching at home, in the review and the registration here at the end, you will be asked if you would be interested in that. If so, please respond in the affirmative. And so my final note is, with so much information that was provided here today from so many kind of across that spectrum, I hope that there was some clarity on what these issues are. Some we were able to answer now, some we know we will learn in time. So all I can say is stay tuned, stay involved as we learn more. Thank you for being here, and I want to thank Vicki Vance, Susan Scheitzo, and Dr. David Burkans. Thank you, everybody.
I want to add one thing. About just a little over 2 weeks ago, Jesse Hill and I were invited to a meeting at Ian's office, and when all this was talked about, and we walked down to the parking lot and said, is he out of his mind? He'll never get this together in 2 weeks. And it's just absolutely amazing, and I think Ian and his staff deserve a real round of applause.
Thank you. Good night, everyone.